Good morning, everybody. My name is Judge Kim Teresa Malika. You're here today in first appearance magistrate court. Today you're going to be informed of the charges and we're going to determine if there's probable cause and determine the conditions of your release. Today is not your trial date. Do not talk about the facts of your case. Everything is being recorded. You have a right to remain silent. The court has gone through a stack of paper here today, and we need to discuss whether you have a private attorney. If you do, please let me know when you step up to the podium. If you don't have a private attorney, you have a right to an attorney. We have a public defender in the main jail, and we also have a public defender, Mr. Reedy, who is here in the courtroom. I'd like to call a couple cases out of turn. Maria Weiner. Good morning. Good morning.
Nice to see you.
Okay, do we have a Maria Weiner anywhere? North Broward, is she there, or Conti, or main jail? Okay. We have a Maria Weiner there. We have Mr. Romero there.
Yes, Judge?
Do you know where Maria Weiner is?
I'm assuming confinement status would probably. Judge, I'm being advised right now by the deputies that she went to court. Oh, confinement status called you guys?
But I
You know
think
that?
someone's
Okay.
covering.
All right, thanks. Yeah, she's in court, Judge.
Okay, hold on one moment. Okay, it's either gonna be Judge Diaz, Judge Evans, or Judge Carpenter Toy, I don't know which one. We're trying to work this out with, the violations of probation. Okay? Evans is on 5, the other two are on, 6. And we're gonna get the paperwork over there.
I just didn't go to Judge Carpenter Toya.
Yeah, fine. All right, thank you. I don't know their room numbers, but if you go up there, their names are outside their doors. You're welcome. Okay, Chantel Laquan Francois, please.
All right, facility, Your Honor.
Okay, are you Chantel Francois?
Yes, ma'am.
Okay, you have counts 6 through 10 for out-of-state holds for felonies. You're gonna be held no bond till you're transferred on those cases. It's in Screven County, Georgia. Okay,
Yes,
ma'am?
ma'am.
Good luck to you.
How long do I have to wait for them to come get me?
You didn't go to your extradition hearing yet, did you?
What? No.
Okay, I don't know where you're at in the scheme of things with regard to, it seems like you have counts here pending in the state of Florida in Broward County.
I have, I just went to court with you Monday. I think it was Monday. I just seen Monday, I had a bond, $80 bond.
Are you sure it was me?
Yes, ma'am. I had magistrate court.
I told you. Okay, well, you have to resolve those cases before they're gonna send you to Georgia. So, reach out, do you have a public defender?
I had a public defender when I came to court. I talked to him on the phone, but I don't know who it was.
Okay, Mr. Reedy, can you just look, we'll have someone come visit you at the jail from the public defender's office.
Okay.
I'll send whoever your public defender is up to see you, okay?
Okay. Do I
Meanwhile,
have to
they'll
bond
discuss the
out?
facts of your case.
Those
Do I have to
cases,
make-
I'm just here today on the out-of-state holds. For that specific purpose, you're gonna be held no bond on those counts.
Right.
Okay, and then they transfer you, we're gonna have to talk about an extradition hearing. I don't know when you're gonna come, we hold extraditions Tuesdays and Thursdays, okay?
Okay.
Oh, you're a doll, Wendy, thank you.
So I
right,
don't
good
understand
luck.
that. I don't understand.
Okay,
Okay,
you have out-of-state holds.
right,
From the county of Georgia, from the state of Georgia. Thank you, Wendy.
right,
You're gonna be held in Broward County until they transfer you up there,
okay,
okay? You're gonna go to what's called an extradition hearing. An extradition hearing is to determine whether you waive the extradition process going up there, meaning you agree to go to the state of Georgia and deal with your pending cases up there. But we can talk
Okay.
more about that at your extradition hearing. I don't know exactly when that's gonna be set. That's totally another separate division. So, but we should be, I'll write your name down and I'll speak to them in the extradition department when you are going to come before me on the extradition, and we can let you know more, okay? But in the
Okay.
meantime, your public defender is gonna come and see you. All right?
Actually, the case has not been assigned a public defender as of yet. We just interviewed her an interviewer is on the way to see you today. So someone from our office will be talking to you today. Okay?
That's who I talked to the other day.
Yes,
Man,
yeah, we did speak with Francois, I remember.
Right.
Okay, good luck.
Okay, thank you.
Thank you. Have a good day. All right, Kimberly Renee Brown, please. Good morning, Ms. Brown. How are you today?
Good.
Okay, you have a municipal ordinance violation, an open container. This is the city of Deerfield Beach. Would you like to resolve your case today?
Yes.
Do you have any other cases pending, ma'am?
I had another open container a month prior, but I went to court for that and I just have a fine to pay.
Okay, I'm sorry, what am I doing with this? Oh, okay, thank you. I'm sorry, what did you say, ma'am?
I had another open container, but I had to go, I went to court for that and I just have a fine to pay.
Okay, I
So
just
other
wanted to
than
make
that-
sure you didn't have a felony pending or
No,
anything
I
like
have
that.
nothing.
Okay, so the court will give you a withhold of adjudication and court costs if you want to admit to the charge today. If not, I can ROR you. Which one would you prefer?
I don't know, I guess I just wanna pay it and be done.
Okay, so raise your right hand. Do you swear and/or affirm to tell the truth?
Yes,
Okay, state your first and last. You swear to. Okay, let me start again. Do you put your right hand up? Do you swear to tell the truth, the whole truth,
Yes.
and nothing but the truth?
yes.
Okay, state your first and last name.
Kimberly Renee Brown.
BROWN.
Yeah,
It's my understanding you wish to waive your right to a trial, ma'am?
yeah.
Anybody forcing you to do this?
No,
Are you under the influence of any alcohol, drugs, or medication?
no,
Ever been treated for a mental illness?
nope.
You wish to plead no contest to an open container with alcohol?
Yeah, yes.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to withhold adjudication and impose court costs of $78. The court will give you 6 months to pay that. Can you hear me okay?
Kinda, something's going off here.
Yeah. All right,
there.
so it's a withholding court cost of $78. I have to impose by law. The court's going to give you 6 months to pay. The court will
Okay.
take judicial notice, ma'am, of the time that you served in the Broward County Jail, okay?
Okay,
You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you.
okay.
Okay, sir, which case do you have today? Okay, who's the last person you have there from Paul Ryan?
Miss Moore Abigail.
Yeah. Okay, give me one moment, ma'am.
Yes, ma'am.
Okay. You're Abigail Marie Moore, ma'am?
Yes, ma'am.
Okay, ma'am, you're charged with public indecency. This is a 2014 case. Can you hear me?
Yeah, I hear you a little bit, ma'am.
Okay. Bond's been set at $2,000. Do you want to resolve your case today, or do you want to go to court and fight this charge from 2014?
Yeah, that's what I don't understand. That was from 5 years ago, and I haven't been living in the state of Florida for 2 years. I live in Georgia now. And
Well,
I'm here for a funeral tomorrow, and that's when I just found out that I had a warrant for that. And that was already supposed to have been taken care of, so I don't know why it's popping up.
okay, it's popping up because you got a notice to appear, and it was returned. Apparently you moved and you didn't have the right court information. So, do you want to try to resolve your case today? It could have implications because of the nature of the case. Or can you afford any type of bond?
Right now, no, because I have no money on me right now. Like I said, I just came from Georgia for a funeral,
Okay.
and I got,
How much money is in your property, ma'am?
my fiance got it, so I would have to call her and ask her how much money I have.
How much do you think it is?
I say about 70.
$70?
Yes, ma'am.
Do you have any credit cards or anything with you?
No, ma'am. Only cash.
And you only brought $70 from, where'd you say you came from, Georgia?
Yes, ma'am. Georgia, Athens.
You only brought $70?
Yes, ma'am. Because I didn't think this was gonna happen. I was just out here for a funeral tomorrow.
No, I understand, ma'am, but we're trying to determine what your bond should be. You failed to appear in court previously, so,
How is that when I left Florida in 2016 of December? And I've been living in Florida for 8 years. I never got no notice at North Lauderdale. That's where I was living at.
okay, ma'am, you got a ticket on December 9th?
2014. After that, they never mailed me a notice when to go to court. And it wasn't even a ticket that the officer wrote me. It was a citation.
You actually got a copy of, you have your thumbprint on there, ma'am. Let me just check the address. Hold on. Okay, do you remember your old address at Northwest 54th Street?
Excuse me?
Do you remember your address at Northwest 45th Street in Coral Springs?
Yes, ma'am.
What was it?
It was in an apartment complex.
I know, but was it 1091 or 10911?
It's 1091.
Okay, that's where it was sent.
Yeah, and that's crazy because I've been left out of that area, but I never received no notice. That's what I'm trying to explain to you, ma'am.
Okay, but when you don't get notice, ma'am, you have to tell people when you move. You have a criminal case pending. Ma'am, I'm not arguing with you. Just listen to me. There's a notice to appear. It went to your address. It got returned because you didn't have a forwarding address. And I do see a thumbprint. So let me ask you this. Do you own any cars? What are your assets? How much money do you have in the bank? Tell me something about your financial condition.
Right now, my parents are living in Georgia right now, and I'm working. I came out here, I bought my plane ticket, and I only had $70 in my name. I don't have no bank account. I hold cash on me.
Okay, how much do you make per week, ma'am?
850. I make 850 an hour. I get
And,
paid every 2 weeks.
and do you work a full work week?
Yes, ma'am.
How much money do you have in the bank?
I don't have a banking account. I keep cash on me.
Do you own a car?
No.
made it like it was Deerfield.
No, she was picked up in Deerfield probably, but it's an MO10 case, so it says City of Fort Lauderdale on it. You look on where it says city. See it? Right on top of where the defendant, and then it says on top city.
All right, this is what we're gonna do, ma'am. We're gonna recall your case. And we're gonna wait for, there's an attorney by the name of McLawrence, and we're gonna wait to speak to him, okay? So just have a seat, we'll recall your case.
All right,
Thank you.
thank you.
Call a case at a turn, please.
Absolutely.
15, Mr. Fred Bender.
What is it?
Fred Bender, page 15.
Okay.
Mr. Bender, come on up here, attorney, Mr. Francis is there.
Is it B-E-N?
Yes, Your Honor.
Okay, I found it. Goodness, okay. All right,
15.
huh? All right, Fred Owens Bender, is that you, sir? Hello, can you hear me, sir?
Yeah, oh, I'm sorry, yes. Fred Owen Bender. I thought you were speaking then.
Okay.
Apologize.
That's
Morning,
okay.
Mr. Bender. Morning, Judge.
Okay, counsel, announce your appearance for the record, defense and state.
Gustavo,
You can go.
Gustavo Francis on behalf of Fred Bender.
Eric Linder on behalf of the state.
Okay, sir, you're charged with aggravated battery on a person 65 years of age or older. We need to determine bond. Court does find probable cause.
Your Honor, if I may.
Sure, you have a probable cause argument?
I do. I have a probable cause objection. This is an incident that occurred on February 15th of 2018. We are now about 3 weeks away from that incident. During the time of the incident, fire rescue sheriff's office came out, and this wasn't even treated as a misdemeanor battery on that time. Apparently, the alleged victim in this matter has ended up in the hospital, I believe yesterday, the day before yesterday, and now they're attributing other things to the misdemeanor battery, and I don't see any connection in this probable cause affidavit to show how the battery from the 15th actually resulted in the aggravated battery. I feel that this should be a misdemeanor battery, which then, based on the age, would probably be elevated to a third-degree felony. But I have an objection to probable cause on a first-degree felony, as I don't see what the aggravated battery is, or how there's going to be a connection from the battery from the 15th to the actual whatever issues he's in the hospital for 3 weeks later.
Okay, it says that the victim, Albertson, the defendant or suspect Bender walked up to the victim and proceeded to violently push the victim with both arms in the chest area, causing the victim to fly backwards, wherein he hit the ground, landing on his back. And then it says the victim is 70 years old and approximately 125 pounds, and your client is 68, 5'11", and approximately 240 pounds. So state, what's your response?
Your Honor, I would note among the injuries the alleged victim said he suffered were injuries to his head, and noting that the injury that he is in the hospital for is a brain bleed, it is not uncommon for someone to suffer internal bleeding, or particularly a brain bleed, and not even realize it initially. So it isn't necessarily surprising that he would have had to go into the hospital at a later date. But since he is in the hospital for injury to his head, and noted that at the time of the incident his head was injured, Your Honor, I believe that is sufficient for probable cause.
Judge, I would just add that by the same logic, he could have bumped his head on that nightstand a month prior and not been aware of the issue. I think this is very far attenuated. This report is written on March the 5th, and it causes a pretty serious enhancement, and this pretty serious enhancement would also result in a significantly higher bond. Whereas if we were just here on just a regular battery on an elderly person, it would be a third-degree felony as opposed to a first-degree felony.
Okay, the court does find probable cause. Let's talk about bond.
Your Honor, we would request a $10,000 bond be set. I've spoken to A Signature Bail Bonds, but A Signature Bail Bonds is willing to take the case. If I can proffer, I have witnesses here, but for the sake of time, Ms. Helen Bender is the defendant's wife. She's a
Spell their
retired,
last name?
Bender?
Bender?
Yes, Your Honor.
Okay.
She's a
Court
retired
reporter
school
wants
teacher.
everybody's last name spelled out for the record.
Sorry.
That's okay.
She's a retired school teacher. Mr. Bender is retired. They live on a fixed income in Century Village. I believe even to put the percentage on the $10,000, she's gonna have to use a credit card and figure out how to pay it. So we have very limited means, and I believe, and I'm saying 10, I would rather ask for 5 or 2,000, but I know the severity of the charge. I spoke with Mr. Linder, and I would ask for 10, I believe would be a fair number that she can afford, and that would also ensure the defendant's presence in court.
All right, tell me what you want in bond and his prior history, please.
Your Honor, I've seen a prior history, and I spoke with Mr. Francis, and I'm going to be requesting a $15,000 bond based on just the level of violence alleged. As Your Honor mentioned, the size disparity between the two parties and the injuries that the alleged victim would appear to have suffered.
Okay.
And I'm sorry, Your Honor, also noting that it does appear the deputy mentions that the incident was captured on video. And obviously we'd be requesting no victim contact.
Okay, I do have no, sir, the first thing I'm gonna order is no victim contact, direct or indirect. That means in person, by cell phone, social media, or even via third party, passing comments to one, sending a message or something like that. And the alleged victim in this case is Dorian Albertson. Do you understand that, sir?
Yes, sir.
Okay.
Ma'am, I'm sorry. Yes, ma'am.
That's all right. All right, sir, you're also not to possess any firearms or ammunition.
Yes, I understand that.
And if you have any,
I have nothing like that.
okay, if you do have any, sir, you're to surrender them immediately upon your release to your local law enforcement. Court is gonna set bond at $7,500. And your address is 1003 Islewood.
D, capital D.
Okay, I have that.
1003 Islewood and then a capital D.
And there's no drive, street, place,
No
and
drive.
that's it?
That just denotes the building within Century Village.
Okay. All right. Why don't you, maybe you can enlighten me, I just wanna make sure that this isn't, someone passing in the hallway type of situation or the parking lot. It sounds like they park near one another, and I just wanna avoid a situation.
Your Honor, it appears this is a the alleged victim works for security, and he was responding to vehicle accident. I was going to speak to Mr. Francis afterwards just to go over. I'm just asking for no direct or indirect contact. I'm not asking for a distance that he has to stay away, because I understand that could be difficult since one works in the community, the other lives in the community.
I think they both live in the community, so there's no way
So
that.
is it a security guard situation, or a?
I'm not clear on that, Judge. From what I understand,
It says on the third victim, Dorian Albertson, who works security for the property. He might live there also, but at this point, I'm just asking for no direct or indirect contact.
Okay, so it's no direct or indirect. If you do see this person, just totally avoid them, walk the other way. Okay, sir? You don't
Yes.
want to get a violation order. Okay? Good luck to you, sir.
Yes, ma'am.
Court setting your bond at $7,500.
thank you, Judge. Appreciate it.
Thank you.
Thank you.
Good luck to you, sir. Okay, Donald LaBelle.
Mr. DeVel's here present as the main.
Okay, Mr. LaBelle, you have an out-of-state hold for a felony. Is this the one? Okay,
It's not a felony.
it's for a DUI. Top paperwork says felony, and it's for a DUI. Okay, this is the situation, sir. Do you want to reset him for later on today, maybe? It says on my paperwork, sir, that it's no bond. However, they're waiting for the state of Pennsylvania to tell them if there's a bond amount. It does say no bond, but commitment needs to get a definite amount from them, whether it's no bond or a dollar amount.
And Mr. Lavelle believes it's a misdemeanor, Judge, not a felony offense on the DUI.
Yeah. It says hold state felony, and then on mine it says driving under the influence drugs. So, I don't know. Okay, is this his only case?
Yes, sir.
I'd rather, if we can, set it for this afternoon, because this is the only thing that's holding him. If you can find out, we have to set him till tomorrow morning, we can do that. There goes the video. Okay?
So are we reset, this up, Judge, or tomorrow
Yeah,
morning?
I'm gonna set it for this afternoon, because this is the only thing
Perfect,
holding
okay.
him, right?
Thank you, Judge.
Is there anything else holding him?
Yes, Judge.
Oh, there is something else holding him.
No, yes, there's nothing else holding it.
Okay, perfect, then we'll reset him for this afternoon.
Thank you.
Thank you. Harriet Hamberry, please.
North Brown, John, she's a medical reset. Your Honor, can you see us at North Brown? Because we can't see you, hear you.
All right, hold on, see. Can you hear me?
Yes, I hear you. I can't
Well,
see you.
yesterday I couldn't see you, but you could see me.
Yeah.
Hi, Craig, it's Judge Malika, how are you this morning? North Broward says they can't see me.
We're gonna check on Danny D.
Okay, well, they just called me now.
Did you wanna check on
Okay.
Danny D.A.N.?
Hold on one moment.
There it is.
There I am, they see me. Conti too, hold on. Is the deputy there, Conti, can you see me? He just called again, hold on. Is any deputy at Conti? All right, I'll call you back, they're gonna call him from here. If there's a problem, I'll call you back, Craig, okay? Thank you so much, bye-bye. Yeah. Okay, Marlene Danny,
What's up?
North Brown, John.
What is this jail call?
really?
Hello.
Okay, hold on. All right, hold on one moment, ma'am. Hello, how are you?
Hello.
Can
Sorry
you
about that.
Can you see and hear me?
Absolutely. Perfectly crystal clear.
Okay, thank you very much.
All right.
Bye-bye. All right, Marlene Danny, please.
North Brown, John.
Okay, good morning, ma'am, how are you? Can you hear me?
Oh, it's so much people on the screen. Could you, like, what is all these 1, 2, 3, 4? What is, okay, Judge, what is your name, ma'am?
My name is Judge Kim Teresa Malika, ma'am. Are you
Okay,
Marlene
my name is
Danny?
Martin. Do you know why I got arrested? I think they doing a black on black crime because for some reason I was walking down the neighborhood the right way.
Let's not discuss the facts of the case, ma'am.
Okay, then what's up? What's tea? I need to understand because I'm so furious right now.
Okay, ma'am, if you'd let me tell you, you're charged with
Okay,
burglary.
tell me right now.
You're charged with burglary of an occupied dwelling, unarmed.
What is dwelling? Like, burglary? I didn't even go to nobody's house. Who said I went to their house? God, strike them. I can't wait. Who's lying on me?
All right, defense, any objection to probable cause?
Well, it does appear, according to the probable cause, that there is probable cause to support the allegation, but it looks like she's peeking in the windows and I mean, I don't know what the relationship between these people is, but I think we're gonna keep an eye on Miss Danny, Judge, as far as bond purposes are concerned. I didn't get a chance to talk to her because I think she was being interviewed by pretrial release or someone when I called up there.
All right, so I'd prefer you speak to her,
Sure.
okay? All right, ma'am, we're gonna, reset your case. Are you gonna talk caller now? All right, ma'am, go to the phone on the left. just, Mr. Reedy's trying to get a hold of her now. Just try. Okay,
I'd ask you to set a nominal bond, and maybe she should really be a medical reset. I can't talk to her.
I'm not gonna set a okay, any objection to probable cause?
No.
Okay, the court finds probable cause.
Your Honor, if I could just have one moment, what I'm
Sure,
printing
my
out, well,
concern is there was a restraining order placed against her that just expired.
and Your Honor, actually, well, before we proceed, do we need her, I guess we need her back.
Okay. Okay, deputy, we need Marlene Danny back. Is this no victim contact?
Yes, but, if I just have a moment.
Okay, deputy at North Broward.
Sorry.
I understand, but unfortunately, we need to bring her back.
Okay, we'll,
All right,
because we had already taken her out, so I'll call her back.
okay. Let me know when she's ready. Okay, Suzanne Zaki. Is there a Suzanne Zaki? Thank you. Mr. McLawrence, are you ready on Abigail Marie Moore?
Yes, Judge. Good morning, Your Honor. She's over in Paul Ryan.
All right, I'll wait till you come over here because I have a couple things printed out for you, okay?
Okay. All right. Thank you, Your Honor.
You're welcome. All right, so we'll go back to our regular Vincent Mark Powell.
Judge, he's here in the main jail.
Okay, Mr. Powell, how are you this morning, sir?
I'm doing pretty good, man.
You have a possession of drug paraphernalia charge. You actually have a capias. You were no-show at your arraignment. Bondsman set at $250. Court obviously finds probable cause. He has a hearing on 3/26. Does he want to resolve it today, or should we be talking about bond?
Judge, he wants to resolve the matter today.
Okay, withholding court costs?
Yes, Your Honor.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, is your name Vincent Mark Powell, Powell?
Yes, ma'am.
Okay, put your hand down, sir. Thank you. It's my understanding you wish to waive your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of alcohol, drugs, or medication?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings, sir, and affect your ability to remain in the United States?
Yes, ma'am.
Ever been treated for a mental illness, sir?
No, ma'am.
Okay, understanding what I just explained to you, are you pleading guilty or no contest, sir, to possession of paraphernalia?
Yes, ma'am. No contest. No contest.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court's going to withhold adjudication, impose court costs, $78. The court will give you 6 months to pay the $78, sir. The court will take judicial notice of the time that you served in the Broward County Jail. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you, sir.
Thank you.
Your Honor, North Broward has Miss Danny back.
Okay.
Hey, you're right.
Thank you. Oh, thank you. All right, Miss Danny, you're back.
Yes, I'm here.
Okay, the first thing, ma'am, the court's going to order is no victim contact, direct or indirect, with the alleged victims in the case, Annabelle Yanez or Maria del Sorcio Vel Chaveria. No contact, ma'am, means not in person, not on the phone, not through third parties, not through social media, not texting or any form. Do you understand? Okay, I'll take that as an affirmative. So,
Yes,
Mr.
I understand.
Okay, thank you.
Your Honor, I provided the court, in addition to the probable cause affidavit, the petition that Ms.
Thank you, Willie.
Chavarria prepared and swore to in seeking the temporary injunction. As you can see, it is similar allegations to the ones before the court. I am concerned going forward that Ms. Danny will not stop going to this woman's residence, going onto her property and trying and possibly successfully getting into her home. Your Honor, I'm going to be requesting a $25,000 bond, pretrial release with a GPS monitor. If she doesn't have employment at this time, I'm going to be asking for level 1 and an order of no victim contact.
Okay, let's hear from the defense about a job, GPS 1 or 2.
Your Honor, Miss Danny would not speak with me, so I can't really tell you very much about her ties to the community. I can tell you that we will be keeping an eye on Miss Danny's case. I think a standard bond would be appropriate. I think a $25,000 situation is. I don't know if she has any money to make a bond, but $25,000 I think is excessive.
Okay, ma'am, do you work?
No, I do not work.
No, she does not work. Okay, the court has a concern for the alleged victims. The court is going to do no victim contact. GPS level 1, $25,000 bond. Thank you, ma'am. Good luck to you. Okay, Mr. Reedy, if you could maybe put a note in her file or contact someone. Okay, thank you. Thank you, thank you. Sir, which case are you here on? Hello. Hi. Lubin, L-U-B? Do you know what page it's on, anybody?
Mr. Lubin is here present, Judge. He is on page 17 of the docket. He's going to be requiring a Creole interpreter, Judge.
I believe we have.
Yes, we have the Creole interpreter.
Thank you. Thank you, Ms. Patrice. She what? She wouldn't talk to you either? All right, do you swear and/or affirm to translate from English to Creole, Creole to English to the best of your ability, sir?
I do.
If you could state your first and last name and spell your last name for the record.
Pierre George, last name spelled Georges.
Okay, thank you very much. Are you Antoine Gesner Lubin, sir?
Est-ce que vous c'est Antoine Gesner Lubin, monsieur?
Oui.
Yes.
Okay, sir, you're charged with trafficking cocaine, 400 grams, between 400 grams and 150 kilograms.
So donc, yo y a accusation contre vous que vous tap vendre cocaïne en quantité de 150 kg.
Bond is set at $250,000, sir.
Nous pral mettre sous yon bon pour yo laguer et quantité cob pour yo laguer c'est $250,000.
Any objection to probable cause, Mr. Reedy?
No, Your Honor.
Est-ce qu'il y a une
Okay, the
objection?
court does find probable cause.
Donc, tribunal la joine que gen bon jan raison pour accusation sa yo.
Let's talk about a bond. What are
Kounya
you,
lan, on nous fait un petit parler sous
what
bon
are you
là.
asking for, Mr. Linder?
Your Honor,
250?
one moment.
Or I should say 250,000.
So donc $250,000.
Your Honor, I'm going to be requesting that the full $250,000 bond be kept in place.
So donc on a demandé pour tout $250,000 qui est en place.
I'm also going to be requesting that the court order a Nebia hearing.
Before the division judge.
Yes, please.
So donc on a pas demandé juge là pour faire une autre audience devant l'autre juge de division.
And full collateralization.
Et donc pour être capable de laguer, il faut qu'il gagne un montant pour collaborer qui monte à $250,000.
Any property used as collateral.
Hold on, I'm writing it down. Full
I apologize.
collateralization.
Any property used as collateral.
Aucun propriétaire que est capable de servir comme
Must remain unencumbered during the pendency of the case.
Donc, il faut que n'importe propriété qu'il t'a lagué temporairement pour laguer là, avec bon ça, faut que li yon propriétaire qui va yon aucun lien sous lui.
I
Hold
would be,
on.
okay,
I
sorry.
gotta write this down.
Sorry.
Hopefully the clerk is too. If not, I have it all written down here, okay? We're gonna talk, I gotta let the defense talk before I decide that.
Your, Your Honor, I'm gonna be, I would request a passport surrender.
M'a demandé pour lui tout déposer ensemble avec nous passeport
From Haiti, right?
Yes.
parce que lui sorti à Haïti pas vrai, oui.
I recognize that might have already been taken by the authorities.
Donc, je comprends que peut-être autorité yo gen ta saisir.
If that
I'm
is
gonna
the,
put by law enforcement, okay? If
Donc,
not taken.
n'a passé l'ordre pour nous saisir passeport li, donc si autorité yo pour faire ça.
I'll follow up to see if it was.
Et m'a continué pour checker pour faire sécurité faire ça.
And that he may not reapply for a passport.
Et il pas gen droit pour appliquer encore pour un passeport.
And pre-trial GPS monitor.
Et donc, n'a mettre sous un programme en vent tribunal avec un GPS sous pied.
And Your Honor, I'm relying upon just the amount of drugs involved in this case.
So donc, juge m'a pas pensé à la quantité de drogue qui était impliquée dans le cas ça.
That it appears Mr. Lubin has no ties to the community.
Donc, il semble que M. Lubin n'a pas aucune connexion à la communauté.
In fact, he was traveling into Florida from another country.
En fait, il était voyagé, il était entré en Floride par moyen dans l'autre pays.
And if convicted of this charge, he faces a 15-year minimum mandatory prison sentence.
So donc, si on condamné pour accusation ça, donc les pourra joindre en 15 ans minimum prison pour pénalité.
Defense, who's arguing this?
Défense.
Judge, as far as the monetary bond,
Juge là par rapport avec Cobb pour la gueule, bonne.
I wanted to know as far as if the state has any in their database any sort of prior contacts between Anton Lubin and law enforcement.
So donc, nous voulons connaître si yo gagné dans ordinateur yo aucun papier qui montre que s'il a aucun contact avec la loi, la police.
Your Honor, my database has no access to. It appears she's from Haiti. My database would not have access to any information out of Haiti.
Donc, tout dossier nous yo, donc, qui soit ordinateur, donc, yo pas aucune information, surtout le fait qu'il était à peine les sautes à Haïti, nous pas aucune information sur lui.
Judge, I'm going to ask Mr. Lubin if he can afford the $250,000 bond.
Donc, m'a demandé M. Lubin, votre honneur, s'il est capable de payer pour $250,000 bonne.
Is there
No.
anybody that you can contact to help post any sort of monetary bond?
Est-ce qu'il y a aucun monde qui est capable de contacter, qui est capable de bailler aucun sorte de comme bonne?
No.
Non.
Do you work?
Est-ce qu'on travaille? In my country.
What do you do?
Qui ça fait dans le pays?
Moi, je suis logistique dans le ministère Jeunesse et Sport.
Répétez.
Moi, responsable de logistique pour sport dans le ministère Jeunesse et Sport.
So I currently work at a logistics office where we currently work with the sport administration when it comes to juveniles.
Okay. How much do you make a year?
Combien de copes que vous faites par année?
Bon, et yo pas calculer par année, juste me toucher 20,000 gouttes le mois.
They don't calculate funds yearly in my country. It's about 20,000 Haitian dollars good per month.
What's the conversion from 20,000 to US dollars?
So, donc, combien que quantité comme ça équivalent à cob américain?
$300.
$300.
I'm not understanding.
About $300 a month.
So, donc, c'est $300 par mois, pas vrai? Américain?
Yeah.
Yes.
Do you any sort of real estate, any sort of assets, anything like that?
Est-ce que vous avez aucun bien propriétaire, caille, terre?
Bien par c'est par son nom et famille et sœur, frère.
So I do have other assets, but they're not under my name. They're under my family's name, brother, sister.
So you don't own any sort of property or assets, correct?
So donc, mais bien ça, yo, c'est pas vous-même qui mettez, c'est yo pas en bas, non. On va parler de terre ou soit aucun bien propriétaire.
No.
Non.
Yeah. In the bank.
Ou pas, comme dans la banque, combien que vous avez dans la banque?
600 good.
About,
Évalué à 10 $ américains.
about 500 good Haitian dollars, which is equivalent to $10, $10 American dollars.
Judge, from all the information I learned from Mr. Lubin, he's basically financially indigent. Imposing $250,000 bond on a person that really is financially indigent, I believe, is tantamount to no bond.
So, donc, selon l'information que m'apprend de M. Lubin, moi que les situation financière qui est déplorable, il pas capable payer pour $250,000 pour bonne.
Now, I do probably understand the state's concerns as far as Mr. Lubin having no ties to this community. However, $250,000, I believe, is excessive, and it's going to basically hold Mr. Lubin no bond here at the county jail.
So, donc, et me comprendre que M. Lubin n'a aucune connexion à la communauté. Donc, le fait que nous imposer un bon de $250,000, faut dire que nous ne pas mettre le sous bon du tout.
So I'd ask you to consider his financial resources in combination with all other factors and impose a reasonable bond on Mr. Lubin's behalf, Judge.
So, donc, m'a demandé, sous plaide, que nous mettions en compte dans la situation financière, avec tout ça que nous connaissons de lui-même, et si nous sommes capables de mettre un bon qui est plus raisonnable.
Okay, this is what the court's gonna do.
Ok, mais ça, tribunal après faire.
Based on the totality of the circumstances, including the lack of ties
Selon,
defendant has to the community,
selon toute information en gros, et le fait qu'il n'y ait pas aucune connexion à la communauté,
court is gonna order a $250,000 bond.
n'a pas imposé $250,000 bon.
There be a hearing before the division judge,
Il y a un autre tribunal audience devant juge division.
full collateralization of the bond,
Donc, il faut qu'ils joignent une série de bails qui quantité équivalent à bon pour y à la gueule.
any property used as collateral,
Aucune propriété que vous utilisez comme équivalent.
any property used must remain unencumbered during the pendency of the case.
So, donc, si vous utilisez aucune propriété équivalent à bon, donc, il faut qu'il n'y ait pas aucun bagage attaché à elle.
Passport surrender if not taken by law enforcement.
N'a demandé que les tout by passeport si autorité pour saisir.
Defendant may not apply for another passport.
Et défendant les parents doit appliquer pour aucun autre passeport.
GPS level 2.
N'a mettre sous un GPS pour suivre lui dans niveau 2.
Okay, thank you very much. Good luck to you, sir.
Merci monsieur et bon, nous souhaitons bonne chance.
Okay, Abigail Marie Moore. Thank you. You know what, Mr. Interpreter, can we have you make an announcement?
Sure.
See if there's anybody else? I'm sorry.
My pleasure. Bonjour, donc n'a demandé est-ce qu'il y a l'autre monde qui besoin de service interprète créole là, qui parle créole.
Okay,
No one else at main, Judge.
Okay, anybody at North Broward, Haitian interpreter?
Est-ce qu'il y a monde qui besoin d'interprète?
We're good, Your Honor.
Thank you. Conti, anybody need a Haitian interpreter? No?
No, ma'am.
Thank you. Anybody need a Haitian interpreter? Paul Ryan.
No, ma'am.
Okay, thank you very much. All right, ma'am, are you Abigail Marie Moore?
Yes, ma'am.
All right, we have Mr. Jara McLawrence. Did you have an opportunity to speak to her?
Yes, Judge, I did.
Okay,
Judge, I wanted to point out a few things to the court.
sure.
First of all, Judge, there's a jurisdictional issue here. If you were to look on the clerk's website, you'll see that court notice was mailed out to Ms. Moore on December 11th of 2014, and it was returned on December 30th of 2014. And there's a difference between the address that was on the notice to appear and the address to which the court notice was sent.
Okay, when I pulled that up before, and I honestly, I thought it was a Pompano Beach case, and I did ask your client, and your client indicated to me it was the right address that it was mailed to.
No, Judge, the address to which it was mailed to did not have the number 1, the apartment number 1, whereas the notice to appear, if you look at the notice to appear, it does have the
apartment number?
Yes, Judge, so the apartment number was missing, and that was probably the reason why she never received any notice.
All right, well, here's the thing. There's a thumbprint, fingerprint that she has. She knew that there was a case, and the court is concerned because she's now living up in Georgia. So I don't know if she wants to resolve this, or if she doesn't want to resolve this. She said she had $70 to her name. So, do you need me to sign something? Okay, you can come over here. Here you go, sir. Thank you. Have a great day. See you soon. Okay,
Judge,
I'm sorry, Mr. McLaurin.
There's as I mentioned, Judge, there's a jurisdictional issue here because the statute of limitations has expired. And I will be making that argument before her division judge, which would have been you, by the way.
I know.
So I would be making that motion to dismiss argument based on statute of limitations before her divisional judge. Judge, it doesn't matter whether or not she knew there was a case. The question is whether or not the city made any effort to contact her when they knew that she never received notice. And they didn't. She does live in Georgia. She told me that she is employed in Athens, Georgia. She doesn't have any, you could check with the clerk's office, I mean, not the clerk, but with the state attorney. She told me she didn't have any criminal history, Judge. I was going to ask if the court would release her on her own recognizance now that I have her information, she has my information, I also have her mother's information, and I would file the appropriate motions.
Okay, what is her updated address?
I have it as 690 Branch Street.
BRANCH, like a branch?
Yes, Judge.
Yes, ma'am.
In Athens, Georgia, 30601.
30601. Okay.
Is that correct, Ms. Moore?
Yes, yes, sir.
I have her email address, I have her phone number, I have her mother's phone number. So I'll make every effort to stay in touch with her, Judge, and to file the appropriate motions. The concern I have about her resolving it, Judge, is as you can see, it's an allegation of.
I know what it is.
Right.
I see.
And I don't know what effect, even though it's a municipal ordinance, I have no idea what effect this might have.
Well, that's what I was concerned about when I was trying to take a plea from her, or even suggesting it. All right, so this is what the court's gonna do. Ma'am, I am gonna ROR you and grant your attorney's request. You need to stay in touch with him. If not, a capias can be issued and you can be extradited back from the state of Georgia to the state of Florida. Do you understand that?
Yes, ma'am.
Okay, I put your address as 690 Branch Street, Athens, Georgia. If you change your address, it's your responsibility to notify your attorney, Mr. McLawrence, and also notify the clerk of court in writing. Do you understand?
Yes, ma'am.
All right, good luck to you, ma'am.
Ms. Moore, just so you know, what I'll do is I will send you an email after court today, and I'll also call your mother and leave my information with her.
Yes, sir. Thank you.
You're welcome. Take care.
Good luck to you, ma'am.
Thank you, Judge.
Thank you, ma'am.
Okay. Any others, Mr. McLawrence?
No, Judge, that's all.
How about I
Judge.
have a county one? Don't you do that?
Judge, yes, I had a conversation with the county.
Donnie Lee Prince?
Yes, Judge, I just had a conversation with the county attorney's office last week, and they have 2 lawyers, and apparently, I've been doing all of them, as you know, but the contract calls for me to do from A through L, and then the other attorney to do from M through Z.
And who is the other attorney that's not showing up? No, I mean, he's entitled to representation.
He is, Judge. It's Mr. Shate, Your Honor.
Okay.
I informed the county attorney's office about the confusion that might cause, and you know, I leave it up to them, Judge, to do it.
Okay, so that's, you do, I just want to put it down here, A through L. Okay,
Thank you, Judge.
thank you.
And Judge, I also gave you the order for the young lady yesterday, Catherine Stefan. We had her in the second look,
Okay,
and I'm
I
not sure.
believe I signed it. All right, so if I can't get a hold of Mr. Shate, what happens if I sign an order today appointing you on this Donnie Lee Prince? I mean, he's gotta be magistrated and he's entitled to representation today.
Judge, I would recommend, if all of these cases where these cities and the counties not providing counsel, that, I mean, it's just be my recommendation, Judge, that you call the presiding prosecutor, which I will, Judge.
All right, thank you. Sure. Okay, what I can do is this on the same case?
It's on the same case, Judge.
We can send it up to Judge Paul. He's the administrative judge. Let's send it up to 5150. We can
Because
give it
we-
to this gentleman.
Well, Judge,
We don't want to give it to them. All right, Willie, you want to bring it upstairs? Yeah.
Judge, I went to Judge Carpenter's toy, okay? And she seemed receptive to take the case, but, you know, it's gotta go through the proper channels to, you know, I think to be.
Okay, we're gonna bring it to, yep. He's 5150. He's the first one off the elevator, okay? Go follow her up to Judge Paul.
Yes, ma'am.
Thank you. All right, we're gonna go off the record. Okay, so Mr. Shade is coming down for Donnie Lee Prince. We're gonna pass him. And then we have Alexander Copeland Messenger. Okay, Mr. Messenger, good morning. You have a trespass failure. You have a trespass failure to leave property upon order by owner. And count 2 is a municipal ordinance. See which place that is. That's Hollywood. All right, we're gonna have to pass this for Mr. Shade to come.
Your Honor,
He's coming. I spoke to him, thank you. Yes.
call a case at a turn.
Yes.
Joseph Kozma on page 10.
I'm sorry, I didn't hear the last.
Kozma,
K?
Kozma. It was a reset, medical reset from yesterday. Page 10.
Okay.
No problem, Your Honor.
Okay, Joseph Kurt Kozma, sir? Good morning, sir. Okay, are you Joseph Kurt Kozma, sir?
I am.
Okay, sir, we have someone in court here today. Can you announce who you are, sir, and your relationship to Mr. Kozma?
My name is Grover Monroe, and I live up the block from him.
Okay,
Mr. Monroe is the alleged, one of the alleged victims, Your Honor.
okay, and that's Monroe, sir?
That's correct.
Okay, we just have to spell everybody's last
No
name.
problem.
Thank you. All right. So, sir, you're charged with 2 counts of assault. Bond's been set on 1 count at $100. The court does find probable cause. Anybody want to be heard with regard to the $100 bond?
Yes, Your Honor. Your Honor, well, actually, if Mr. Monroe could be sworn in, I believe he wants to testify to safety concerns he has.
Okay, Madam Clerk.
I do. My name is Grover C. Monroe, Monroe.
Who is Maria Monroe?
That's my wife.
Your wife? Okay.
Yes, ma'am.
I didn't know if it was a sister or
No, that's my wife. Thank you.
mother or something like that. Okay. All right, so go ahead, Mr. Linder.
Mr. Monroe, without going into the allegations of what occurred on Monday, could you please tell the judge what, if any, safety concerns you have both for yourself and your wife?
Yes, I do. He threatened both myself and my wife's life. Okay, he's got a previous track record of causing problems in the neighborhood that has to read like a scorecard to a Yankee game. I mean, the police are there all the time. He's a danger. He threatened my wife's life and mine, and I take it seriously because I've been nothing but nice to him. And
Hold on 1 second. Sir, don't respond, okay? You have an attorney here in the courtroom. Go ahead, sir. I'm sorry, I didn't mean to cut you off. Yes, I'm speaking to you, Mr. Kozma.
you want me to continue?
Yes.
Okay. I tried to be nice to the guy. Neighborly, he needed $10 at the convenience store. I gave it to him. Then a few days later, he came to my door for more money, and I told him I can't afford to do that. I'm a bus driver. I just helped you out in need. I thought everything was fine with him. But every time I would walk my dogs, he would holler obscenities and things and constantly badger myself and my wife. And all I tried to do was be nice to the guy. I never did anything to him. But for whatever his reasons, then he started yelling and calling me out by name. So I addressed him and I called him out on it, and that's where the problem began.
Okay, thank you.
And I just want to please clarify the fact that he's dangerous. He's had situations where he shot up a house in our neighborhood, and I'm fearful for myself and my wife's life, and I take it very seriously. And I hope the court does as well, because I don't know what it is, but they keep letting this guy out. He's a terrible problem. Any neighbor will tell you. I'm in the process of getting a ledger together from all the people backing me up on this to try and get rid of him. He's a definite problem. Thank you.
Thank you, sir.
Your Honor.
Do I get to respond to that?
No.
Your Honor, and I recognize that at this point in time, he's charged with 2 second-degree misdemeanors. That being said, my concern for Mr. Monroe, Ms. Monroe's safety really goes beyond the degree of offenses that Mr. Kozma is charged with. I have concerns about his mental health. As I noted yesterday to the court, Mr. Kozma is still being, he still has a conditional release review before Judge Porth for charges of 3 counts of attempted murder against a law enforcement officer.
So that's pending?
He was found not guilty by reason of insanity, but it's, and I spoke to the prosecutor assigned to the case in Judge Porth's division, and I was advised Judge Porth finds the matter serious enough and has enough concerns about his mental health status that he is, even from, and it's a 2007 case, but he's felt it necessary to continue to have jurisdiction over the case and supervise, have over his release and review of it. Your Honor,
GPS, or just what level?
I wasn't aware.
Such officer.
Your Honor, lastly, we see all sorts of different threats that are alleged that come before the court, but certainly when a threat is made to kill someone, it doesn't get much more serious than.
To kill them.
Mr. Kozma, don't discuss the facts of the case. This is not your trial. It's just for the. It's
Why
a,
can't I discuss the facts?
because everything that you say is going to be used against you. Mr. Monroe is not charged with a crime. You are. So anything you say can be
So I
used
can't
against
respond. It's not
you. No,
fair.
no, this is not the time to respond, Joseph. This is really just not the time to respond.
It doesn't get much more serious than that, Your Honor. In light of the information I provided to the court, in light of the information that Mr. Monroe has provided, I'm going to be requesting bonds on the amount of, on count 1 and count 2 at $10,000 each. No victim contact, pretrial release with a GPS monitor level 1. And additional order that Mr. Kozma not be in possession of any firearms, weapons, or ammunition.
Have any firearms?
Number that he is actually on conditional release for.
Okay, just give me 1 second, I'm just writing something down. Hold
Give me a
on,
look like
please.
the devil himself. Fuck this is bullshit.
Mr. Kozma, calm down, please. You're not helping yourself. Take a deep breath.
I don't even get to respond.
You will, but not right now.
Okay, go ahead, Ms. Patrice.
You're on the case number that the state informed you that he's on conditional release being supervised by pretrial is 0723884 CF10A.
And what are those charges?
3 counts of attempted murder in the first degree and 1 count of shooting into an occupied dwelling.
Okay, I'm sorry, 3 counts of attempted murder. Michelle just whispered something to me. What'd you say?
Good morning, Michelle. 1 count of shooting into an occupied dwelling.
Okay, defense?
I'm not even clear why he's being supervised. It looks as though this case has been disposed of.
Your Honor, my understanding is when it's disposed on those type of grounds, that the mental health court can retain jurisdiction for supervision purposes.
Am I correct in stating he was found not guilty of these offenses?
I said earlier, he was found not guilty by reason of insanity, and my understanding is, in that situation, and it's within the discretion of the mental health judge to retain jurisdiction.
Judge Ford.
Yes, ma'am.
I would ask the court not to take any action on that since Mr. Kozma has already been found not guilty. If Judge Porth wants to do something about that, I think that would be in his purview to do, not Your Honor's, especially in light of unusual circumstances, aside from the fact that it's a very old case of 2007. He's been acquitted. Albeit by reason of insanity, but I would ask the court.
I'm not taking any action on that, so
Okay,
talk
that's
about
fine then, Judge.
bonding.
All right, Judge, Miss.
I can tell you, I am gonna order no victim contact.
Yeah, we have no problem with that, Judge. We are in total favor of that. I would just point out, I'm looking at Mr. Kozma's Broward County criminal history, which is really all I have access to. And since 2007, I don't see any arrests for any violence whatsoever. Mr. Kozma has been living in the same house, which he owns, for the last 17 years. He collects Social Security. He has been living in Florida since 2001. He does have family here. He's also provided me with the name and number of a friend of his who he believes will be able to bond him out. His friend does not have a tremendous amount of money. I appreciate the state's concern, and I appreciate what Mr. Monroe had to say also. No weapons are involved in this case. We don't know how close Mr. Kozma was to Mr. Monroe and his wife when these threats were allegedly made. He is willing to stay away from them and not have any contact with them, but he's not going to be able to make a $10,000 bond on a second-degree misdemeanor. And I think that that's asking way too much as far as bond is concerned. I'd ask the court to consider leaving the bond where it is and putting Mr. Kozma on a GPS monitor so that we know where he is at all times, with a special condition that he have no contact with Mr. or Mrs. Monroe.
Okay, I wanna do a minimum amount of feet. Maybe you can call the neighbor back up and he can describe how far apart their homes are,
All right.
just so that we know.
Well, I spoke to him earlier, and the impression, what he told me, he believed it was about 125 to 150 yards. I can look online for more,
Okay, why don't we do that?
We didn't even get close personal
Let's say,
contact.
and Mr. Kozma, understand, you're putting yourself at the scene.
Okay.
You know, you don't even need to put yourself at the scene. That's something the state has to prove, unless you help them. If there are any other elements of their case you'd like to help them with, keep talking.
All right, then. I don't understand all this. All I understand is this is not right.
and frankly, Your Honor, while I'm looking, that's also why I was requesting level 1, because
Does he work?
He collects Social Security, Your Honor, and he does some side work.
Mr. Shate, we'll get to you right after this. We actually have 2 of them for you. Would you like to see them, Mr. Shate? Why don't you come up? I don't know which one you have, so. Oh, okay. It's Hollywood.
I'm showing, and the court's aware, according to Google directions, and it says by 26 Way, which is the street that connects the 2 blocks, it's approximately just under 338 feet.
Is there any way you can print out a picture so I could get a visual and see it?
Yes, ma'am.
I don't know where, maybe you can use Mr. Reedy's phone to speak to the other person you didn't speak to if you want. We'll call you right after this.
I didn't speak to either one of them.
Oh, okay.
I would just ask them.
You don't want to try to resolve their cases?
I would like to try to resolve it, I'm sure, but one's just sleeping and the other's just soliciting the roadway.
All right. Okay, Mr. Linder, hold on. So, is this,
Those are the 2
you can
addresses.
come up, I just want to, not familiar with this map, I just want to make sure where I put the circles, is that their homes?
Those are the 2 addresses, Your Honor, and it has listed below the approximate. And Your Honor, the just.
Okay, so he can go the other way, it appears. Who's 2623?
That would be Mr. Kozman.
Okay, so Mr. Kozman can go around the block, the other way.
Yes, Judge, and he would agree to do that.
Okay, Okay, can you show this to Mr. Linder? Can you give it to him?
Mr. Reedy?
I mean, Mr. Reedy, I'm
I
sorry.
printed him
I have a copy.
Okay.
again, Your Honor. Well, and the state's request is for level 1. So.
Okay, anything further, Mr. Reedy?
No, Judge. I think Mr. Kozma understands when he leaves his house, he'll be making a right-hand turn on Northwest 55th Street, not a left-hand turn.
Okay.
Your Honor, my concern is, based on the information we have before us and the fact that Judge Porth finds it significant enough that he has to continue to supervise him, I can't have much confidence in what Mr. Kozma either does or does not understand, or what will voluntarily or will not voluntarily follow.
Okay, sir, you're to have no contact, direct or indirect, with Glover Monroe or Maria Monroe. No contact means, sir, nothing in person, no texting, no calling, no contact through third parties, nothing through social media, no liking anything, disliking anything, or commenting. Do you understand, sir?
I do.
Okay. Next one is no possession of any firearms, ammunition, or weapons. If you possess any, you're to surrender them immediately upon your release to your local law enforcement. You also are going to be put on GPS level 1 and maintain a minimum of 300 feet from the residence located at 2618 Northwest 54th Street, Tamarack, Florida. Court is going to do on each count a $7,500 bond based on the totality of the circumstances in this case. The court is not taking any action on 0723884 CF10A. I'm going to leave that to Judge R.A. Porf's division, because I feel it's more appropriate in this case. Okay, Mr. Shate, thank you, sir. Good luck to you. Mr.
Your Honor, before we move on.
Oh, hold on a second.
Yeah.
Okay, sir, can you come back, please? What did I not do?
What?
$7,500 on each count.
I just didn't hear. Your Honor.
Oh, that's okay. No problem.
I don't have that kind of money at all.
All right, sir, you can go before your division judge. Thank you. Good luck to you. Okay, hello.
All right, I'm going to try and set up a bond hearing for you, Joseph, okay, in front of your division judge.
All right.
Hi, Judge. Good morning. Sid Fleischman. I'm here on behalf of Diane Vassal. I was in front of Judge Rothschild this morning. We had an arraignment on Mr. Vassal's case, but they did not bring him over.
What page is he on here?
It was the last case on the docket.
Judge, what I'm...
Okay, so you want him brought over to Judge
well,
Rothschild?
no, I already entered not guilty plea, but
Okay.
he's in front of you to address the ad charge, attempt second-degree murder.
Okay, so let me get him over here.
He's at the main.
Do we have a Doyon Vassell?
Yeah, that's him.
Okay, good morning, Mr. Doyon. We have a capious ad charge, add 2, and change of charge, a grand jury indictment. So,
Your Honor, you had Russell Nelson as co-defendant yesterday.
okay.
I believe you recall the case. This was the murder at a gas station.
Yes.
At Mr. Vassal's first appearance, you found proof evident or presumption great. He's now before the court. He's been indicted for first-degree murder with a firearm. He was charged with the attempted second-degree murder. I provided the court with the paperwork yesterday, the sworn statement from the alleged victim, whose initials are RL, and the 911 report documenting his injuries. Your Honor, I would ask the court, one, on count 1 to, I don't know if count 1's before the court also.
Judge,
Murder premeditated.
Okay. I would ask the court to rely upon your previous ruling on count 1 for first appearance purposes only for finding proof evident or presumption great. On count 2, and I spoke to Mr. Fleischman, I'm going to be requesting the same bond that you had set on Mr. Nelson, which was $250,000, and no victim.
On 2?
Yes, on the attempted secondary
So
murder
no
with a
bond
firearm.
on 1 and $250 on 2?
That's what I'm requesting, yes, Your Honor, and no victim contact with the alleged victim by the initials RL.
Okay, so it says capious felony. I'm going to write in for count 2. Attempted murder, second degree, is that correct?
Yes, it is, Judge.
Judge, what I want to explain is we were in front of Judge Rothschild this morning for his arraignment. I entered not guilty plea. They didn't bring him over because he was here, which I didn't know he was going to be here.
Okay.
But what I would ask you to do is not do anything with the bonds, because I'm filing my bond motion actually today for an Arthur hearing. And that Arthur hearing is going to be done in front of Judge Rothschild. So I don't see how the court could make any findings of proof evident presumption great, because obviously you haven't seen, I guess all you saw was a sworn statement. But the Arthur hearing will be held in front of our trial judge, Judge Rothschild.
Okay, here's the thing, he's being magistrated on these charges, and the state's asking me,
Well, I don't have, Your Honor, Mr. Fleischman doesn't have an objection for first, and we had a case similar yesterday, for first appearance purposes, for the court to order him to be held no bond, and obviously it's for Judge Rothschild to make a determination. I have no objection to that.
In other words, I'm asking you, I'm going to present everything to Judge Rothschild.
okay, not a problem, perfect.
Because
Okay,
250,000 is the same as no bond, so I'd rather just have everything heard in front of Judge Rothschild.
Okay, so just correct, count one is murder premeditated, count two is capious felony, just want to make sure.
Yes, ma'am, yes, count one.
Is attempted murder, second degree, with a weapon. I didn't get to say with a weapon last time.
Yes, ma'am.
First count's gonna be no bond, second count is 250, no contact with any co-defendants in this case. And proof evident, presumption great, findings,
Well, Judge, okay, well,
I was gonna put will be heard before Judge
right,
Rothschild.
exactly, yes, okay.
Put state and Attorney Fleischman agree to count one, no bond. Count two, 250,000. And okay, I put further arguments, findings be heard before division judge. Okay,
Okay, thank you.
you're welcome. Good luck. Here you go. All right, so,
Which one would you like to address first, Judge?
doesn't matter.
Okay.
Call the case.
Did we have Donnie Prince?
Okay, Mr. Donnie Prince. Does anybody know where Donnie Prince is?
He's Donnie Prince. Hold on one moment, Judge. He's approaching, Judge.
Okay. All right, are you Mr. Prince?
Yes, ma'am.
Good morning, sir. You have a charge of Broward County ordinance violation for, doesn't say what it's for.
Judge, it looks like he was sleeping in a park outside the hours that he's allowed to be there from 8 to 9. It looks like he was sleeping there around 11:45 in the evening on June 14th of last year.
Okay, in the city of Hollywood?
No, Judge, this is a Broward County ordinance.
That's right. The other one's Hollywood, right?
It looks like it was located in Fort Lauderdale, but I think because BSO probably picked him up,
Uh-huh.
that they
Yeah,
charge
he has
it.
a 1698 Blount Road as an address. Okay.
Judge, it's, he fell asleep at a park, Judge. I'd like to see if we could just have him time served. Is that what you'd like to do, Mr. Prince? Would you like to take an offer to time served?
Yes, sir.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth? Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am, I do.
Okay, put your hand down. Is your name Donnie Lee Prince, Prince?
Yes, ma'am.
It's my understanding you wish to waive your right to a trial?
Yes, ma'am.
Anybody forcing you to do this, sir?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Okay, you want to plead no contest to the county municipal ordinance violation, sleeping in a park?
Yes, ma'am.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file. And finds probable cause for the plea. Adjudication, time served, $78 in court costs, 6 months to pay. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you, sir. Stay out of the park after hours, okay?
Yes, ma'am.
Good
Thank
luck
you.
to you. Okay, Alexander Copeland Messenger.
Good luck, sir. Mr. Copeland, messenger is here present, Judge of Maine.
Okay, we have, sir, count one, trespass, failure to leave property upon order by owner, which is a misdemeanor case, I believe, an MM case. And then we have a municipal ordinance case, which is prohibited roadway.
Correct, Judge. Looks like
Apparently he was panhandling.
correct. Judge, on the MM case, that wouldn't be mine, that would be the public defender's office, but on the MO case, I would ask that he be time served for soliciting in the roadway.
Judge, and speaking Mr. Copeland, I addressed count one, I believe it was from a 7-Eleven store, Judge. Yeah, if that's the allegation, he has no problem not going back, and he wishes to ask the court for adjudication time served.
Okay, sir. Do you agree not to return to the 7-Eleven?
Yes, Your Honor.
Okay, state any objection? Adjudication time served?
No, I'm fine with that.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, Your Honor.
Okay, put your hand down. Is your name Alexander?
Alexander.
Alexander, they don't have an R here. Copeland Messenger, Messenger?
Yes.
Okay, it's my understanding you wish to waive your right to a trial in the trespass case and the municipal ordinance case. Is that correct, sir?
Correct, miss.
Okay, and all the questions I'm asking you are gonna be on the trespass case and the municipal ordinance case. It's my understanding, is anyone forcing you to do this, sir?
No, Your Honor.
Are you under the influence of any alcohol, drugs, or medication?
No, Your Honor.
Ever been treated for a mental illness?
Yes, Your Honor.
Okay, don't tell me what it is. Does your mental illness affect your ability to understand?
No, Your Honor.
Let me finish the question. Does your mental illness affect your ability to understand what's going on here today with clarity?
No, Your Honor.
Okay, understanding what I just explained to you, you're pleading guilty or no contest, sir, to trespass, failure to leave a property upon order by owner, and the municipal ordinance of being in the roadway, sir.
No contest.
Okay, the court's gonna accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court's gonna adjudicate you and time serve you on each count. Court's gonna impose court costs of $78 in the municipal ordinance case. The court will give you 6 months to pay. On the trespass case, the court is gonna impose court costs of $293, which is the amount I have to impose by law, and the court will give you 1 year to pay that, sir. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Sir, don't return to the 7-Eleven, okay?
Thank you, Your Honor.
You're welcome. Good luck to you.
Thank you, Judge. Have a
Thank
wonderful
you,
day.
Mr.
Take
Shade.
care.
Sydney Hall.
Mr. Hall is present here at Main, Judge. He's approaching. Come on up, Mr. Hall.
Okay, Mr. Hall, you are charged with exposure of sexual organs in public. Court does find probable cause. Are we referring this case to Judge Wren?
Yeah, I don't know if she'll take it, but I mean, if she doesn't, then it'll get sent back to division.
All right, can I have an order for Judge Wren, please? I have one here, yeah. Okay, all right, sir, we're gonna keep the $100 bond in place, and we're gonna send you to Judge Lerner Wren.
Your Honor,
Go ahead.
I'm just gonna ask, should he post his bond or be released at some point, court order that Mr. Hall's not to return to 235 South Fort Lauderdale Beach Boulevard.
Okay. No return.
Judge, what I'm going to be requesting is, since being Mr. Hall, he's 70 years old. Right now, unfortunately, from what he advised me, he is homeless. There's nobody that can post his bond. This is a first degree misdemeanor. It's $100 bond. $100 bond is something that he does not have at this time. Judge, he did advise me he gets Social Security $730 per month. He's at this point not going to receive that towards the end of the month. So right now, financially, he doesn't have $100. Judge, I'm just asking, what would you consider a pretrial release, Mr. Hall?
No, court's referring him to Judge Lerner Wren, thank you. Good luck to you, sir. Can we get him in on Monday to see Judge Wren?
I'm
'Cause she's away?
texting, I'm sending a message to her
Okay.
JA right now.
Tell him Monday, he'll probably go, Mr. Romero, before Judge Wren.
Yes,
Okay,
sir.
Trent Shirley, please, and then we have Andre Philippe Roldan.
Shirley's at the...
North Broward, Judge.
Okay, Trent Shirley.
How you guys?
Hi, how are you, sir?
I'm great.
You have possession of cannabis, 20 grams or less. Court does find probable cause. Hold on, sir, don't talk about the facts of your case. We have an attorney, Mr. Reedy, in the courtroom who's very capable of representing you. Bond's been set at $100.
I already have a lawyer.
You do? Who do you have?
Yeah.
Jason Kaufman is representing Mr. Shirley on a separate case. I spoke with Mr. Kaufman this morning. I also spoke with Mr. Shirley's mother this morning. Mr. Kaufman cannot be here. He has not been retained on this case yet. He's indicated to me what the progress of Mr. Shirley's other case has been. And there are still some evaluations that need to be done in that particular case. His mother indicated to me that she would like to see him out. I'd ask the court to consider releasing Mr. Shirley, maybe on pretrial release or to his mother's custody.
State, any objection? Okay, standard pretrial release.
Thank you, Judge. I'll let his mom and Mr. Kaufman know.
Can you guys explain what that means? Pre-trial release?
It means you're going to have to check in with the sheriff's office within 24 hours of your release, but you won't have to post a bond, so you'll be released from jail today. The map that you just got handed shows you where it is. It's down here in downtown Fort Lauderdale. You're going to need to check in with them initially and then call them. How many times a week do you want them to call, Judge?
Standard, twice a week.
Twice a week. You have to call them up and let them know how you're doing, all right?
Alright. That's all?
That's it.
Alright, you guys are.
All right.
rock.
All right. Good luck, Trent.
Andres Roldan. Okay, Andre Roldan.
Yes, sir.
Okay, his bond's been posted. Good news, sir, okay? Good luck to you, sir. Sir, hold on a second. Is your address 10703 Northwest 81st Street, Tamarack?
Yes, ma'am.
Okay, if your address changes, you gotta notify the clerk in writing, thank you.
thank you.
Marquise Lumpkins, please.
Mr. Lumpkins? Judge, I've been advised he declined the service of public defender.
Okay, Mr. Lumpkins, you have trespass other structure. You're being charged with, you can't tell if he failed to appear in court, it appears he did. $1,000 bond's been set, state.
I'm just checking the allegations, Your Honor, to see if this is a case I can make an offer on, if he wants me.
Sir, would you like to potentially consider resolving your case today?
Yes.
Okay, the state attorney's gonna let me know if they have an offer for you.
Yes, ma'am.
This case up to 17.
Your Honor.
Yes.
I'm printing out the original report. I just
Yeah,
want.
I can't get a copy of it. So much for CMS.
I do have some concerns upon reviewing the report. That being said, I would be willing to offer Mr. Lumpkins an adjudication 5 days in county jail, but I want to put it on the record, and that's why I wanted to provide the court with a copy of the report, that if should Mr. Lumpkins come before the court arrested for trespassing at this location again, the offer would, at least the offer from the state would involve substantially more jail time, because I do have some concerns based on these allegations.
Okay, sir. The offer is 5 days Broward County Jail adjudication defense.
He declined the PD, Judge.
Oh, he did?
Yes.
Okay, sir, so it's an adjudication and 5 days Broward County Jail.
And, Your Honor, obviously, in order no return to 286 Southwest First Terrace in Deerfield Beach.
Okay, sir, 5 days Broward County Jail. You want to do that? Yes.
No.
Okay, then your bond's gonna stay at $1,000, sir. Okay?
I was saying, like, can I get ROR?
No, sir, you failed to appear in court. You got notice.
I was saying I had went to court. I had went to court last month for when I had got in a car accident, and they said I had a warrant for this, for the cases, for the trespass. She said she gonna upheld it, and I could go back to court for it. I went to court in Plantation.
Okay, this is what the court's gonna do, sir. Court's gonna order no return to 286 Southwest First Terrace, Deerfield Beach, Florida. You're maintained 500 feet.
Yes, ma'am. Oh, that's it.
Court is gonna put you, hold on, sir, I'm not done. Court's gonna put you on a GPS level 2 open schedule, ROR. Thank you, sir. Thank you. Joseph Retta.
Mr. Red is your
Obviously,
present judge in Maine.
if
He is the
that's
president.
near his house, obviously he can go to his house. We'll have to readdress the 500 feet, okay? So I don't know if we can put something in that order that he's allowed to go to and from his house, obviously. Joseph J. Retta, you are charged with count 1, petty theft, second degree, first offense, bond set at $25. Same thing for count 2, except the court's gonna ROR you. And then you have count 3, a capious misdemeanor, where bond's been set at $250. And that is for operating without a valid license.
Judge, Mr. Red is interested in resolving his cases today for time served.
Your Honor, I have no offer for Mr. Retta. The property from these two thefts was not recovered. I'm gonna be asking for a bond in the amount of $250 on count one. He was.
Well, hold on, it says on the first one that he ran out of a store, I thought. and
That,
left all the
he
stuff
wasn't
there.
arrested for that theft. He was arrested for the theft on February 21st on the next page and February 23rd.
Okay, that's correct.
He was convicted of grand theft in Broward 2017, 2016, 2015,
I
and,
see that.
one moment here, I just want to see one thing.
Hold this case, please.
Your Honor, I'm showing. I believe Mr. Retta is on probation for his 2017 grand theft. I'm showing Judge Usan on April 27th of last year, placed him on 3 years probation.
So he's on probation for grand theft?
It would appear so, Judge. And if you want to check it out or not, I can give you the case number.
Vincent Powell. I usually
It's
give
okay,
it to the
I'll-
clerk. No, hold on. Just give me a moment. Patience.
No, I just don't want to do that. Other things you got.
Which case is this?
I was lumped
We're
in.
not in a race. Okay, I probably stapled it, so look there. Oh, I didn't know you wanted it back. I apologize.
No, I didn't know it.
Okay. All right, sir, so we're not resolving your two cases today with the petty theft. What about the no valid DL? That can violate him on his probation? 'Cause he's on felony probation.
Yeah, I'd have to see when it occurred.
What's the date on this, when he was charged?
I mean,
He
it's
got a citation 12518.
it would appear so then.
Is that,
He was placed on probation in April of last year.
so he got a petty theft, and he's out on grand theft. What's that case number?
He's 17-1375 CF10A. Your Honor, if the court was inclined to hold him on that, it would have to be for a violation of probation under Florida Statute 94806.
Do we even know if he's on probation? I know when he was sentenced, and I know the length of the probation, but we don't even have anything before us here to tell us that he's on probation today, or that he was on probation back in February.
Says he was put on probation for 3 years, 2/4/17, for grand theft. So state, am I correct?
Your Honor, I believe you have the same paperwork I have from DOC that shows active probation status, and it gives the charge case and,
He was put on probation in 2015, that's the offense date. How do we know?
no, he was originally placed on probation on those cases 2015, 2016.
So he was put on probation in 2015, 16, and 17, each for grand theft.
Yes, ma'am.
And what are you asking for with regard to the 17-13-75?
Well, it's, Your Honor, I believe it's up to the court to make that determination. I'm just advising the court that it is under Florida Statute 94806. Since you have found probable cause for new law offense and have reason to believe that he's currently on probation on the 2017 case, it is within your discretion to order him to be held under that statute for violation of probation.
Okay, defense.
Judge, right now, he's not gonna be able to afford the $25 nor the $250 bond. I don't know if there's questions regarding his being probation, not on probation. Certainly, if he is on probation, his probation officer could submit a warrant, for his arrest, to have a judge sign. So Judge, I'd ask you at this time to not take any action on this, considering there's a lot of things going on, Judge. I know initially he wanted to try and see if he can resolve the case. At this time, in abundance of caution, I'd ask you just to leave the bonds in place.
Okay, the court's gonna ROR him on both. Court does find that there has been a new law violation pursuant to 94806 in case number 171375 CF10A. He's gonna be held no bond, according to the Department of Corrections. It says in 2015, he was charged with grand theft. 2016, 2017, he was sentenced in 15, 16, 17, and placed on probation each year, and he's still going out, allegedly, to Beals. There's no return to Beals, sir. Good luck to you.
Judge, I don't know if I heard you correctly. Did you say ROR on the new law offenses and on the habeas misdemeanor?
Yep.
Judge, at this time, I'd ask you, if you're holding him no bond, he's gonna be held no bond already. I'm gonna ask you to at least leave a $1 bond in place on counts 1 and count 3. Therefore, he's still getting his gain time. If not, then he's basically doing dead time, not getting any sort of credit. His physical body's still being here, held in jail.
Okay, court could take judicial notice of the time that he served, but in any event, I'll do a $1 bond on each charge, okay? Thank you.
Thank you.
Rakeem Baptiste.
Mr. Baptiste is here present, Judge.
Okay, Mr. Baptiste, you have a possession of cannabis, 20 grams or less. You have a capious misdemeanor. You failed to show for arraignment. State.
Your Honor, the state would offer Mr. Baptiste a withhold court cost judicial notice of time served.
Okay, does he want to resolve the case today?
Judge, actually, he does not wish to resolve the case today. From what he's advising me, he didn't get notice for it. He was wanting to go to court, address this charge. I don't think he has an extensive record or a record, Judge. Judge, at this time, we'd ask you to considering this as a cannabis offense, we'd ask you to consider an ROR, and we'd ask you to double check what address the clerk's office has on file for Mr. Baptiste, so he can get proper notice.
Okay, let's pull up this case, 18-000-445.
Looking at the capious, I can tell you it was sent to the same address that's on his booking sheet.
What's his address?
What's your address, sir?
206
Southwest.
Say that
10th
again,
Street.
sir. I was looking at something. I'm sorry.
206 Southwest 10th Street, Hollandale 33009.
That's where his court date notice was mailed to.
Is it a house or apartment?
Duplex.
Duplex.
But they can't tell, they don't know what number.
Oh, so it's a duplex, Judge, so I don't know if it went to the right duplex. And from what I was trying to find out, how did they identify which duplex? And I'm trying to get that answer. Hold on one moment, Judge.
Could have got mixed up.
Judge, from what he's advising me, the way his mailbox is set up, on top of the mailbox, there's 206, 204, and beneath it are two mailboxes. So it doesn't identify which number pertains to which specific mailbox. So it's logical to believe it could have been mixed up.
I don't.
Okay, this is what the court's gonna do. He can't afford a $500 bond? What can he afford?
Let me ask. Judge, from what he advised me, he told his wife last night to bond him out. If he hasn't bonded out, he believes that his wife couldn't come up with the funds, couldn't find money to post his bond. So the question you're asking, he does not know right now. And Judge, did the state say he has a lengthy record or anything like that?
I don't know that we even got into that.
Well, that's what I wanted to ask as far as like his record, Judge. I believe he has a clean record, and if he does, he didn't get noticed. It's logical. I explained the mailbox situation. It's a cannabis offense. That's why I think I'm asking for something reasonable in ROR.
Possession of cannabis, 2014. He was convicted of false ownership info on a pawn item, 2014. He violated his probation.
He's getting the last chance, oral, standard pretrial release, okay?
Yes, Judge.
ROR, standard pretrial, thank you. Jonah Michael Green. Mr. Green, you're charged with disorderly intox in a public place causing a disturbance. This was the one at the tattoo parlor, I believe. All right, bond set at $25. Court does find probable cause.
Judge, my understanding is, in speaking with Mr. Green, he did speak to his girlfriend. However, if he's still here, he does not know what happened. I believe from what he told me, he had a cannabis in his past, but it was dropped. He's working at Applebee's. He's been there for about 4 months. Disorderly intoxication, Judge, would you consider an ROR on this new law offense of $25?
I mean, he hit someone with a closed fist. He not only did hit one person, he hit two persons, the owner and an employee. Okay, state, any objection to ROR?
As long as there's an order of no
return.
return to Color Fast Tattoo.
No problem, Judge. He has no problem going back to location.
Okay, ROR, no return to Color Fast Tattoo. Thank you.
Thank you.
Joseph Salvatore Iemolo.
He's here present, Judge. Yes, Your Honor.
Okay, good morning, sir. You have drive with a suspended revoked license. You're a habitual traffic offender, it says. $100 bond.
He advised me, Judge, his parents are posting his bond. He believes it may have already been posted.
You also have some other charges: expired DL over 6 months, failure to register a vehicle, operating a motorcycle without a license, license not carried, and driver present, non-current proof of insurance. Do we know if his bond's been posted? Okay, next one's gonna be Anthony Navarro. We're checking on your bond, sir. Okay, bond has not been posted yet. You might wanna reach out again to your parents, okay?
Thank you, Judge.
Sometimes it does take a little bit of time. Anthony Navarro, and after that is David McDougal. Good morning, Mr. Navarro. You're charged with knowingly giving false info to a law enforcement officer. Court does find probable cause. $100 bond has been set. Can you afford that bond, sir?
Judge, this is the problem. He does not think he can afford to post his bond right now. He believes his parents may, but this is the situation. His parents live in New York, 75 years old. I believe from what he advised me, they really don't know how to go about doing that or anything like that. So, having said that, Judge, he's 34 years old. He's been here, living here 6 years. He's working. He works Firebird Wood Grill, which is approximately a 20-minute walk from his apartment, and that's how back and forth to work. He's living at Pembroke Pines. My understanding, he has a misdemeanor offense in New York, but he's relocated down here as a registered voter. He doesn't own any property, so right now he cannot post his bond. That's why he's trying to reach out to his parents. So I'd ask you to consider an ROR on this misdemeanor offense, Judge.
First off, Your Honor, I'm concerned about the allegations that he's making false calls, providing false information, essentially to try to get someone arrested or investigated for child abuse, when he acknowledges that none of it is true. I would also note that he was arrested in Dade County last year for a warrant out of the state of New York and had to be extradited to Nassau County. He additionally has a warrant right now out of Dade County for failing to appear in a traffic matter. He's got a $2,100 bond on that. So, I mean, I've got concerns regarding his contact with, and it appears this person is known to him. I believe they have a child in common. And about his future appearance in court, because he's demonstrated he doesn't show up in court.
Okay, keeping the $100 bond, he doesn't show up to court, thank you.
And Your Honor, because it would appear that she's a witness, I would ask, or they're both witnesses, I'd ask for no contact with Jennifer Hickey and Brett Potvin.
Okay, no contact, direct or indirect, sir, with those two persons. That means no contact through, in person, on the telephone, texting, emailing, anything on social media, okay, sir?
No problem.
Thank
Yes,
you.
ma'am.
David
Good luck, Judge.
McDougal?
Medical research, Your Honor.
Vernon Keith Adams, please.
Yes, ma'am. North Broward. Yes, ma'am.
Okay, good morning, sir. You have resisting an officer without violence, bond set at $100. You also have trespass, failure to leave property upon order by owner. There's no bond attached to that. The court does find probable cause.
Your Honor, Mr. Adams indicated to me he'd like to resolve these matters today if possible.
State? I can tell you it's gonna include no return to the Haven Hotel at 3001 Southeast 6th Ave.
Yes, ma'am.
Mr. Adams is agreeable with that, Judge.
Does that mean
Yeah,
he agrees not to go?
Yes, ma'am. It agrees not to go back to that motel.
Okay.
I'm fine with the time served plea with no return, Your Honor.
The state's offer is adjudication time served. Do you want to accept that offer, Mr. Adams? Resolve your cases, enter a plea of no contest? Okay.
Yes, sir.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, sir. Yes, ma'am.
Your name's Vernon Keith Adams,
Yes, ma'am.
ADAMS.
Yes, ma'am.
It's my understanding you wish to waive your right to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication, sir?
No, ma'am.
Ever been treated for a mental illness?
Yes, ma'am.
Okay, does your mental illness, don't tell me what it is, but does it affect your ability to understand what's going on here today, sir?
No, ma'am.
Okay, so
No, ma'am.
so you want to admit to the charge and plead no contest, sir?
Yes, ma'am.
Okay, and that's to resisting an officer, obstructing without violence, and
Yes, ma'am.
trespass, failure to leave property upon order by owner?
Yes, ma'am.
Okay, and you agree not to go near the Haven Hotel?
Yes, ma'am.
Okay, the court's gonna adjudicate you on each count, time serve you, impose court costs on count one, $293, 1 year to pay. The court costs and no return. Good luck to you, sir. You have 30 days to appeal the sentence of the court. The court finds your plea is freely and voluntarily entered after reviewing the court file. Thank you. Yes, sir.
I have inmate Elamine Shabazz on page 21. He was a previous medical reset. He's not feeling well.
I have no problem. Give me, spell the last name.
Shabazz. He's on
Okay,
page.
anytime you need me to take a case out of turn, please let me know, okay?
Thank you
No
very much.
problem. Okay, Elmine Shabazz.
Good morning, y'all.
Good morning, sir. How you feeling today? Not feeling good?
I'm feeling well, y'all.
Okay. All right, sir, you have count one, possession of MDMA, which is ecstasy, bond set at $1,000. You have a capious felony. I believe that's from Judge Rothschild. remember correctly. Yes, it is, I was right. For a felony petty theft, you're being held no bond, you didn't show up for a hearing. So you do have a no bond hold on count 2 for the possession of MDMA. The court does find probable cause. What would you, request, Mr. Reedy, as far as $1,000 bond?
Mr. Shabazz did not wish to speak with me, Your Honor, so I have no information regarding his ties to the community.
Okay.
But it doesn't really make too much of a difference. He's got the no bond hold,
Correct.
so he's not going anywhere. He needs to appear in front of his division.
Okay. Okay, you failed to appear previously, it's alleged, sir. You have a no bond hold on the KP as felony for the felony petty theft. You didn't show in front of Judge Rothschild, I believe that was on March 2nd, 2018. I'm sorry, it was actually on February 28th, 2018. This was just signed and clocked in or received on March 2nd. So the court's gonna keep the bond at $1,000, sir. Good luck to you, okay? Frank Cadet, please.
He's gonna be a medical reset, Your Honor.
Okay,
Thank you.
thank you. Jared Kofer?
Conti.
Okay, Mr. Koper, you have, I believe this is an ad charge, count 14, KPS felony, criminal use of personal ID. Bond has been set at $3,500. Court does find probable cause. State?
Your Honor, you've had Mr. Coe for the past couple days. I think one was on a change of charge yesterday. He had a motion to release 2 days, I guess on Monday. I'm just asking that the court keep the $3,500 bond in place. He's got much higher bonds with the Nebia requirements on these
So
cases.
why don't we just ROR him on it, no? I mean, he has all these other.
Well, I'd ask for a nominal bond, Judge, so he at least continues to get time served on it.
And Your Honor, I'm just asking, he's got to go in front of his judge. It really, if he can't get out before he sees his judge anyways, isn't it optimal to let the trial judge, who's going to be overseeing the case, make the bond determinations? I would agree.
$3,500 bond. Thank you,
Yeah.
sir. Good luck to
Your
you.
Honor, can I
That's
say-
without prejudice, okay?
Of course.
Can I say something before you?
Yes, sir.
I was honest.
Absolutely.
Okay, I came Monday for the motion to be released, my charge, and it was, I guess yesterday it was a change of charge. Okay, I said something to you about it the first time. The change of charge, I have it here, it went down from a second degree to a third degree. My bond, I never seen my judge yet on the charges. The state said that it was monetary bond set at $25,000, which my judge didn't set that. Whoever the judge was that the detective went to and got the warrant signed, he's the one who said it. I spoke with my lawyer. My lawyer said that once I come to magistrate,
Who's your lawyer?
that's Cheryl Cohen.
Is that private or public defender?
She's a public defender, Judge.
Defender, Mr. Kofer has a status hearing in front of Judge Howery on Tuesday.
Yeah, I
And
know.
it looks like a bond motion has been filed by Ms. Koenig.
Okay, so you have a hearing, sir, March 13th. That's
She's-
next Tuesday at 8:30.
That's the bond motion is for the 13th.
Is that the bond motion?
No, it's not.
I suspect it might get set then.
Yes.
All right, this is what we can do, sir. We're just here today on the KPS felony.
Yes, ma'am.
$3,500 bond, but you have a no bond hold. You can go before the judge and address all your bonds then.
Okay.
You know what I'm gonna do? I'm gonna do $1,000 bond, and I'm gonna put without prejudice. Okay,
Thank
sir?
you, Your Honor.
You're welcome. Good luck to you.
Okay.
Next one is Cedric Cornelius Johnson.
Your Honor, I'll wait till you get out.
Okay, are you Mr. Johnson? Okay, you have something to say before I read the charges?
Well, I was just going to say, Your Honor, I have no objection. Obviously, we'll have his first appearance. I'm just asking that the matter be reset for tomorrow for a probable cause determination pursuant to the rules of criminal procedure.
Okay, sir, you have burglary of a dwelling or structure or conveyance armed. There, we need to talk about bond. You have petty theft, second degree, first offense. There's no bond attached to that. And you also have ride without hand on a handlebar, which is a civil traffic infraction. There's no bond attached to that. So what's the objection to probable cause?
It's not an objection, Your Honor. I'm asking under the rules of procedure,
What rule?
3.133A1. It says in all cases in which the defendant is in custody, a non-adversarial probable cause determination shall be held before a judge within 48 hours from the time of the defendant's arrest. He was arrested March 6th at 6:43 in the morning. I'm asking that the probable cause determination be reset for tomorrow morning, which will be,
Why?
because I want to get more information, Your Honor.
Okay, defense?
Based on what I have in front of me, I don't see anything about riding on the handlebars or petty theft. I have a feeling there's a lot of incomplete information here, which I suspect is what Mr. Lender is getting at. It's also very unclear as to how this is armed. It just says that he armed himself with a Taurus, but there's no further detail or any kind of substance to this probable cause affidavit. I'd ask the court to make a finding of no probable cause.
Your Honor, but
Well, the court's gonna give him 24 hours to perfect, if that's what he wants, if we find that there's no probable cause.
Is that what he's requesting? Is that what the state is requesting, to perfect?
that's not what I'm requesting. I'm requesting, as permitted under Rule 3.133A1, the probable cause, it only requires a probable cause is determined, or determination is made within 48 hours. The first appearance has to happen within 24 hours. It does not require that the probable cause determination is made within 24
Okay,
hours.
is this a punishable by life offense or
Yes.
first? Okay. Three point one three three one A?
Yeah, A1, yes, Judge.
A1, I'm sorry. Okay, so you want to continue it till tomorrow morning?
Yes, ma'am.
Any further response?
Yes, we object. We ask the court to conduct Mr. Johnson's magistrate hearing now, since we're all here.
Okay, the court's gonna reset it and grant the state's request pursuant to the Florida Rules of Criminal Procedure. 3.133A1 for 3818 at 8:30 a.m. Thank you.
See you tomorrow morning, Mr. Johnson.
Okay, Jason Alexander Bullard.
Your Honor, I believe Mr. Bullard is represented by private counsel Michael Weinstein. I have called his office and spoke with his assistant. They have not contacted me back. Can I have a minute? I'll give him another call.
Sure, we're just gonna reset this for this afternoon, sir,
Okay.
unless you wanna try him fast.
I'll try him right now, Judge.
Okay. Okay, Mr. Bullard, we're gonna try to contact your attorney again. In the meantime, let's call Elio Roberto O'Neill.
Mr. O'Neill's approaching, Judge.
Okay, Mr. O'Neill, you have driving while
Hey,
license
Brian
is
Reedy here,
suspended.
still in Judge Malika's
Habitual
courtroom.
offender, we can hear you
Oh,
again.
maybe I didn't.
$750 bond's been set.
Oh, okay. 6172.
We do have warrant and revocation for violation of pretrial 12345. I'm sorry, 2345.
Yeah.
See what it's alleged, took off your monitor or something. Did abscond from your residence.
Okay, thank you. Bye-bye.
Does this mean that the GPS, Madam Pretrial is gone? it says he did abscond from his residence with the electronic monitoring transmitter valued at $575.
Hey, Michael, Brian Reedy here in front of Judge Malika.
I thought I first heard,
We've got Jason. You're
I heard it was
How about
worth
yourself?
$1,200, I thought.
Good. We've got Jason Bullard here. And do you want to? We don't know yet.
But one is how much is that worth? Okay.
Okay. I'll ask if
All right,
that's.
so did he abscond with the
Let me,
monitor, meaning
until when
is
she
it
finishes
gone?
this case, I'll ask her. Just stand by.
Did you ever find it, do you know?
Yeah.
No, just hang on. It's only take a second.
I mean, I said, Your Honor, I don't
He
know,
wants
but I
to appear by
suspect
phone.
it was gone, considering the warrant was signed in 2014, and if he still had it on his ankle, they probably would have been able to find him pretty quickly.
Okay, so what does that mean? He left his residence when he wasn't supposed to?
Wherever he was supposed to be, it reads like he took off.
Okay, why am I getting this back?
All right, I'll call you back.
For Cedric Johnson? No, that's the one that we reset till tomorrow. Hold on one second. I have three things in front of me. Cedric Cornelius Johnson. Wasn't that the one that we just reset for, that's reset for tomorrow?
Yes.
Okay, and then for Mr. Weinstein, it's Jason Alexander Bullard.
He's standing by.
Is he coming?
He would like to appear by phone.
Sure.
All right, I'll call
So
him. Do you
right
want to call
now-
him, Judge?
You gotta give me his number.
I will.
Do you want to finish Mr. O'Neill?
Yes, I do. Everybody's talking to me all at once. There's only so much I can do. So, I'm multitasking. Elio Roberto O'Neill. So we have driving while license is suspended, and then we have these warrants, VOP pre-trial. And I was just asking, did he remove the monitor? Does anybody know that? If you don't know, that's fine. Okay. All right, thank you. All right, so court does find probable cause. Anybody want to be heard with regard to bond?
No, Judge, considering as a no bond hold.
Okay, sir. 750 on 1, 2, 3, 4, and 5. You have no bond holds. Thank you, sir. Good luck to you. Henry William Dixon. Let's just take this one and we'll call him one moment. I
Dixon,
forgot.
come on up, please. He's here present, Judge, I mean.
Okay, Mr. Dixon, you have false owner info for pawn items less than $300,000 bond, dealing in stolen property, $3,500 bond. We do have violations of probation on 3, 4, 5, and 6. You have no bond holds on those charges. You are going before your division judge, who is Judge Tim Bailey, on March 12th, which is Monday at 9 a.m. Does anybody want to be heard with regard to bond on 1 or 2? Or probable cause?
Oh, no probable cause argument.
Okay, court does find probable cause. Court's gonna leave the bond at $100 and $3,500 on 1 and 2, considering he has no bond holds on 3, 4, 5, and 6. Monday at 9 a.m. before Judge Tim Bailey, sir. Good luck to you. Okay. Let's go side. Okay, can we bring Jason Alexander Bullard back? Gotta hit the button, sir.
Right here, ma'am.
Okay. Hi, Mr. Weinstein, this is Judge Malika calling you from First Appearance Court. I have Jason Alexander.
Judge, how are you?
Good morning, how are you? Okay, the court has Jason Alexander Bullard in front of me. He is charged with 1 count, possession of weapon or ammo by other state felon. We need to talk about setting a bond, actually counts 1 through 4. Count 2 is leaving the scene of a crash involving damage to property. Count 3 and 4 are the same, aggravated assault with a deadly weapon without intent to kill. So, there is a warrant to arrest. The court is gonna find probable cause. Let's talk about bond.
Well, let me address this, Judge.
Okay.
As you may or may not know, Mr. Bullard was arrested in the courtroom yesterday on a status conference for another matter. And he knew that there was a possibility he would be going to jail, and he still showed up for court. So he's a lifelong resident of South Florida. His mother lives in town, so he's got strong ties to the community. And knowing he could have been arrested, he still showed up in court. So it shows he's not a flight risk whatsoever. I would just ask that you set the standard bond.
Okay, state.
It wasn't a status conference, Your Honor. The state had filed a motion to revoke his bond because Mr. Bullard was out of custody uttering a forged instrument in grand theft. And while out on that case, it didn't even involve these charges. While out on that case, he was, and I believe it's mentioned in the affidavit, he was arrested, I believe, for grand theft auto and carrying concealed firearm. And that was the basis for the motion to revoke bond. And now he's before the court.
But he did show up to court for that, knowing that he could have been violated. I'm just saying, that's the point he's making.
Yes.
Okay.
Mitigator, he showed up to court. Aggravating factor, this is now his third open, actually third and fourth open felony charges. And now allegedly using the same firearm that he was found arrested for carrying concealed firearm previously.
Okay, so tell me what you're recommending for bond on 1, 2, 3, and 4.
I'm asking on counts, well, 2, I'm fine with an ROR, it's a traffic matter. On 1, 3, and 4, I'm requesting $7,500 on each count. No victim contact, no firearms or weapons, ammunition until further order of the court. Pretrial release with the GPS monitor.
Okay, no victim contact, direct or indirect. Who's the alleged victim?
Initials are
And we'll get to the bond in a second, Mr. Weinstein.
Thank you, Judge.
KA.
Okay, sir, there's no victim contact, direct or indirect, with the alleged victim in the case with the initials KA. That means no in person, no calling, texting, anything on social media, including liking something, disliking something, or through third parties. Do you understand that, sir?
Yes, ma'am.
Okay. What's the second thing you requested, Mr. Linder?
No firearms, ammunition, weapons.
Okay, any objection to no firearms, ammunition, or weapons, sir?
Okay.
No, I'm asking Mr. Weinstein, I'm sorry.
Yes, Judge.
No objection to no firearms, ammunitions, or weapons?
No objection to that. I just wanted to speak regarding the amount of bond.
Sure, no problem.
Yes, correct.
Okay, anything else, Mr. Linder, with regard to restrictions?
No, Your
Said
Honor.
GPS? Did you say that, yes or no?
Yes, I did ask that, Your Honor.
Okay, GPS, does your client work, Mr. Weinstein?
What's that? No, Judge, he's not working right now.
Okay, all right, go ahead, let's hear bond and your comment to GPS.
Judge, I just would ask again, because he did show up in court knowing he could go into jail, and the amount that the state's asking for is extremely high, over $20,000. I would ask the court to consider a lesser bond, such as $2,500 a count. That would equate to $7,500 for the 3 counts, which I think is sufficient, especially showing his ties to the community, the fact that his mother came to court yesterday, that I can proffer, the fact that he knew he could go to jail, he still showed up. I think $7,500 is sufficient. Furthermore, I don't know that a GPS is necessary. I mean, if you want to put him on pretrial, I would understand, but I don't know that a GPS is necessary, all things considered. And speaking to his mom yesterday, he's definitely innocent until proven guilty, and I heard, as far as this case, and again, I wasn't there, but I'm hearing there's 2 sides to every story. So.
Okay, this is what the court's gonna do. 2,500 on 1, ROR on 2, 25 on 3, 25 on 4. There's no victim contact, sir. Again, I'm gonna remind you, with the alleged victim, KA, you're not to possess any firearms, ammunition, or weapons, and GPS level 2. Thank you, good luck to you, sir. Thank you, Mr.
Thank you, Judge.
Weinstein. Bye-bye.
Thanks, Judge.
Okay, Fabian Luis Baez. Okay, are you Mr. Baez?
Yes, ma'am.
Hey, good morning, sir. You have a petty theft, second degree, third offense. Bond is set at $750. It's actually, even though it's a petty theft, it's being charged as a felony. You have count 2, carrying concealed firearm. $1,000 bond's been set, and you have count 3, possession of weapon or ammo by convicted Florida felon. Total bond is $2,750. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. Let's hear with regard to the $2,750 in bond. Anybody wish to be heard?
Your Honor, I'm asking for a bond increase
Okay,
on count 2 to 2,500, count 3 on 5,000. I am concerned that, and it appears to be strong evidence that for some reason Mr. Baez illegally brought a firearm into a Publix.
thanks, Willie. Pardon?
Oh, I thought I heard you say something.
I said, thank you, Willie. He was reminding me to possibly take a break. Okay, so let's hear about bond. Mr. Romero, go ahead.
Judge, I'm going to be asking you to leave the standard bonds in place. Right now, he's not working. He's currently looking for work. The only person that he believes that could potentially post his bond is his mother, but unfortunately his mother is not working. So therefore, he was hoping that somehow his mother could go ahead and come up with the premium, with the bonds of what the standard bond is right now. But seeing the bond on counts 2 and 3 to $2,500 and $5,000 on count 3 is something that his mother's not going to be able to afford. So, Judge, we'd be asking you to consider leaving the bond as is at this time, Judge.
Okay, there's no return to the public, sir, at 4121 West Commercial Boulevard, Tamarack, Florida. Not to possess any firearms or ammunition, which you already know you're not supposed to do. Next thing is GPS level 2. Court's going to keep the bond. $750, $1,000, and $1,000. Good luck to you, sir. Okay, next one is Giovanni Garcia, and then after that is Hunter Scott Martin. Okay, is there a Giovanni Garcia? Okay, removed. Actually is a court order. All right, Hunter Scott Martin, and then we have Dominic Andre Elver.
Mr. Martin, is here present?
Okay, Mr. Martin, you have 2 capious felonies. You have no bond holds. Actually, they're not for magistrate. And then counts 3 through 8, you have capious misdemeanors. You also have no bond holds. On those, you are going to appear before your misdemeanor judge for counts 2 through 8 in front of Judge, I believe it's, Judge Sharon Zeller on March 8th, which is tomorrow at 1:30 p.m. I'm sorry, you also have a 9th capious, which is a no bond hold as well. Okay, so pending your hearing,
I emailed it to you.
the public defender, someone will be out to see you, sir. If you're not, if you haven't. Okay, does someone represent him from the public defender with all those capiouses? I just don't want him sitting in jail.
I'm sure somebody will be there tomorrow, Judge.
Okay, what about on the felonies?
We'll take care of them.
Okay, thank you. Dominic Andre Elver.
He's here present.
And then Jorge Alberto Marino. Okay, Mr. Elver, you have count 1, possession with intent to sell, manufacture, or deliver cannabis, $1,000 bond, trafficking in heroin between 4 and 14 grams, $75,000 bond. Count 3, driving while license is suspended, First offense, $100 bond. Any objection to probable cause?
Based on Mr. Elver's level of cooperation with the authorities, no, Your Honor.
Okay. Let's talk about bond.
Mr. Elver's out on bond and release right now before Judge Uson for possession of cannabis with intent to sell, possession of drug paraphernalia, and DUI property damage.
What was the bonds in those cases?
Cannabis with intent was $1,000. There was no bond attached to the drug paraphernalia. $500 on the DUI.
Okay. Okay, he was driving a Mercedes. Let's hear about bond. Waiting for you. Can't hear you.
We're gonna hear from Mr. Lender as far as what he wanted.
Asking that, considering that he's out on a
He wants
felony,
go
petty
ahead.
felony, I'm asking that the bonds be kept in place.
Okay, he said keep them in place. We were waiting for you. I guess you didn't hear him. Go ahead.
Okay, Judge, I'm gonna be asking you on this time, to consider reducing the bond on count two. It's $75,000. At this time, what he advised me, he works for a Realtor office. He's an office assistant. He's been there for about 2 years, making about $12 an hour. So he gets paid roughly about $30 to $40 a week. He tells me that his check were in the neighborhood between like anywhere from about $450 to $500 a week. That's how much he gets paid. He's leasing that Mercedes. The lease is $400 a month. So basically what he's doing is paying off the lease, the insurance, the gas is what he's working for. He's going to school to Broward College. He's studying business. He's a sophomore. He's on financial aid. He lives in North Florida with his father. His father basically works at Wells Fargo in customer service. He takes care of all the expenses as far as the rent and everything like that. I believe the rent is $1,000 a month. So he's his father is basically supporting him. Judge, there's no way he's going to be able to meet the $75,000 bond. There's no way his father is going to be able to meet the $75,000 bond. We just asked you to consider reducing bond on count two from $75,000 to $25,000.
Your Honor, could the court inquire who he's leasing the Mercedes from?
I believe it's Luxury Auto, Judge.
From who?
Can you repeat that?
Luxury Auto.
I don't understand why, according to DHSMV, the 2013 Mercedes that was acquired March 28, 2017, has an owner, listed owner of Lizette Otero. Imagine if it was a lease, the listed owner would be the corporation.
Okay, the court's gonna keep the bond in place. All the ones that are here, 1,000, 75,000, 100, GPS level 2, open schedule. Thank you. Jorge Alberto Moreno, and then Daryl Kimball. Okay, are you Mr. Moreno?
Yes, ma'am. Yes, Your Honor.
Okay, sir, your bond of $5,000. You have actually 3 charges: grand theft between $300 and $5,000, grand theft $300, $5,000, $1,000 bond on each one. You also have an out-of-state hold for a misdemeanor charge, $2,000 bond, and someone posted your $4,000 bond. Okay, let me just check your address, sir. Is it 5278 Northeast 6th Ave,
Is that your address?
Yes, apartment 1990.
Oakland Park?
Yes, ma'am.
Okay, good luck to you, sir. If your address changes, make sure you let the clerk of the court and your attorney know. Good luck to you. Daryl Kimball?
Mr. Kimball, the present judge, you decline the service of defendant. Good day, sir. Yeah.
Okay, Mr. Kimball, you have possession of MDMA, ecstasy, $1,000 bond. And then you have count 2 is possession of cannabis, ROR, drug paraphernalia, ROR, attaching a registration plate not assigned, ROR, violation of probation misdemeanor, ROR, but you do have a probation violation, sir, for your community control, which you have a no bond hold, which actually isn't for magistrate today.
Community control, I never had community control.
Probation or community control, sir, they put down either or, okay?
Oh,
So
okay.
you do have felony probation,
Mm-hmm.
it appears, but that's not for magistrate anyway, but you do have a case that is gonna be set in division, in front of Kathleen McHugh, which is division MV.
I have a question, Your Honor.
Go ahead.
The case with the attached tag, I called my wife yesterday. She fixed that. The DMV, it was
Okay,
a
don't
dealer.
talk about it, because that's not holding you, you're ROR'd. So I don't want you to admit or not
Oh,
admit to
okay,
anything,
okay.
okay? So
I
this
appreciate
is
that.
the situation, sir. You have a no bond hold, and then you have a possession of MDMA, which is the ecstasy of $1,000.
Okay.
So, state. Keep
Your Honor,
the 1,000, or what do you want to do?
With all those holds, I'm just asking that the bonds be kept in place.
He actually doesn't have holds. He only has one.
Oh, well, I'm sorry, I thought it was someone else, but even with one, is it a no bond hold?
Yeah.
I'm just still gonna request that the bonds be kept in place.
Okay, sir, can you afford to pay the $1,000 bond?
Yeah.
Okay.
That's 10%, right?
Yes.
All right, yeah, I'll pay that.
All right, but you do have the no bond hold you have to deal with, okay? So
That's no
contact
problem at
a
all.
public defender or a private attorney. But as far as the case here today, the court's gonna leave it at 1,000. The no bond hold does not have anything to do with magistrate court, okay?
Okay.
ROR and all the other ones, yes. Rocky Stone Stimple.
He's here, President Judge May.
Hello, sir. How do you say your last name?
Stemfield.
Stimple, okay. All right, sir, you have petty theft, second degree, third subsequent offense, bond set at $750. That's for a felony. Resisting an officer or obstructing without violence, bond set at $100. Pardon? Okay, count 3 is robbery with a firearm. We need to talk about, there's no bond hold. We have count 4 and 5, violation of probation for a felony. Count 6 is petty theft, second offense, $750 bond, that's a felony as well. Count 7 is a violation of probation or community control. Actually, it's a violation of probation, no bond hold, and he's gonna be going before Judge William Howery on March 13th, which is next Tuesday at 8:30 a.m. And then he has petty theft, second degree, same thing as 1 and 6. So 1, 6, and 8 are all petty theft, second degree, $750. State?
Your Honor, on count 3, first, if I could ask, on your findings, does it say robbery firearm?
Yes.
Okay, yeah, it should be robbery deadly weapon.
Okay, because it says armed, so
Yeah.
put robbery, deadly weapon,
The
okay?
the alleged deadly weapon, in this case being a machete. Your Honor, I showed Mr. Reedy the affidavit, relying upon the arrest warrant affidavit, and this is a punishable by life offense. The state will be seeking a no bond hold and a finding of proof evident or presumption great for first appearance
On
purposes
count
only.
3,
Yes, ma'am.
and the other count? Leave the bonds as is?
That's what I'm requesting.
Okay.
Your Honor, in light of the fact that Mr. Stimple has no bond holds for violation of probation, we will defer any argument regarding proof evident presumption great until such time as he can appear in front of Judge Howery.
Okay, the court is gonna have reviewed the probable cause affidavit and the other documents filed in your case, and I find probable cause, I further find the proof of guilt to be evident and or the presumption great. Therefore, sir, on count 3, you're gonna be held without bond until further order of the court. This is without prejudice for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. On count 1, $750 bond, count 2, $100, count 3 is no bond, let me just put PEPG found. Count 4 and 5 are no bond, count 6 is $750, count 8 is no bond, and count, sorry, is 7 is no bond and 8 is 750. So 750, just for clarification, is 1, 6, and 8. And you do have a hearing March 13th at 8:30 a.m. What about no victim contact or anything?
Your Honor, I'd ask for an order of no victim contact, and we can supplement with initials or name at a later date.
Okay, sir, you're not to have any contact, direct or indirect, with the alleged victim in this case, who they are going to supplement to you what the initials are for the alleged victim. No contact, direct or indirect, means no contact in person, no contact via telephone, texting, social media, or through third parties. Do you understand, sir?
Yes, ma'am.
Thank you very much. Okay, Craig Devin Davis, and then we have
Bonded.
Austin James.
Craig Davis bonded.
Okay, I heard you. Then we have Austin James Raprago Wade.
Did, bonded.
Thank you. Philip Leonard Santoro.
Medical loan?
How's he doing? He's
I don't
had
know.
quite a few medical loans.
Yeah, I think we're gonna maybe send someone out to see him, Judge.
I think you should. Let me just see when this offense was. We have a medical loan, 3635. 31, 31, 32. We did find probable cause on 3-1. No objection by state or public defender. Bond needs to be set. When was he arrested? 225. 224, 225. Okay. Jack Mark DeGraziano, I'm sorry.
Mr. DeGraciano is here present, Judge, at Maine.
Hold on one moment, the clerk was speaking to me. Go ahead.
Oh, I thought you announced his name, I'm sorry.
I did. Go ahead. All right, so what were you asking to do, Madam Clerk? Not keep resetting them? All right, do you have any
Okay.
objections, State?
There you are.
Okay, so that's what we'll do, Madam Clerk. Thank you for the suggestion. Okay, Jack Mark DeGraziano.
He's here, Judge, at Maine.
Okay, sir, you have count 1, possession of methamphetamine, $1,000 bond. Possession of drug paraphernalia, $100 bond. Expired DL over 6 months, $25 bond. Possession of gamma, which is GHB, $1,000. Then you have 2 violations of probation for community control. You're going to be held no bond on those. Any objection to probable cause?
No, Your Honor.
It actually says he is going before his division judge, Michael Lynch, on 3/13 on Tuesday at 9 a.m. Has that changed? Because it's written here, Madam Clerk, on here, but not here. That wouldn't change, would it? All right, so maybe we can get his VOPs to go to his division judge tomorrow, which is Judge Michael Lynch. Okay, so we found probable cause. Let's talk about bond. Anybody want to be heard?
The judge, considering he has a no bond hold, Judge, at this time, we defer any sort of arguments in front of his assigned judge.
Okay, so we're going to leave the bonds in place. Is that okay, State?
Judge.
Okay. Okay, last one is Jeffrey Scott Kubish, or Cubsch, Cubsch. Is he with you?
No, Judge.
See you at 1.
Thanks, Judge.
I'm told Mr. Kubich is downtown in the courtroom, in the courthouse today, Judge.
Does anybody know where he is?
No.
Can we look up this case, 1600 5067 CF10A? He had a medical reset so many times. Okay, so it appears that it's probably in front of Judge Lynch. All right, so when do you want to reset him for?
Put him on tomorrow's docket just to make sure that everything got taken care of with Judge Lynch this morning.
Okay, any other issues for the court? Anything else from anybody?
Shredder upstairs too.
All right, see you at 1.